to this matter. This matter was heard on 20th May, and Myra was kind enough to direct the matter to be placed for hearing. And this is the matter regarding the appointment of the FARS operator. The matter, let the match's date has now been fixed. By order dated 20th, let the matter be fixed on any date. My lord, these are the orders which your my lords have passed on this matter.
Let me see first. Okay.
It will mention two matter I have mentioned earlier twice, but did not appear. One as regards the some rifles equipment policy.
Writ petition.
I know.
Group 6.
One service matter, one claim case. Claim as regards the
Which are the numbers?
one in 2022 and another is 2025.
নাকি দুবার মেনশন করেছে আগে?
Twice mentioned, my lord.
Give the numbers.
My lord, I mentioned this matter.
And just mention the dates on which you had earlier mentioned. Otherwise, sir, how will I ask the department? I need to, they have not received the files. Have you?
I have.
No, not today's. You said that you had mentioned earlier on 2 occasions.
Yes.
So write those dates because they definitely send the requisition to the department. They don't keep it pending.
That was not noted in my diary, my lord.
Then, sir,
My lord, I remember.
have you served notice?
One appeal.
Whether it is appeal or a group 6 matter, did you serve notice upon the other side that you are mentioning today? Please do it, sir.
My lord, I have mentioned this matter several times, but it is not. And last time mentioned on 13th August. I have written where the file is lying. That also. It is urgent, my lord. They have filed the execution case.
So that is why you have come. Since they have filed the execution case.
No, I
Don't
have
matter it,
mentioned several times.
Must
have
filed
it in a separate court. Yes.
For a minor correction is there. Lord.
Correction.
Yes.
Okay.
My lord, may I have a lordship mention, my lord? This is a service matter, my lord. 2022, my lord. Petition is out of employment.
What do you want, sir? Inclusion in the list. Have you served notice?
My lord, I shall inform today, my
No, sir. You first serve notice and then come. I mean, you people are mentioning. Thereafter, the matter is coming in the list. No one turns. Now, what I will do? I will send administration on mentioning is taken up. Nobody is found for good practice. Next.
My lord, may I have a lordship kindly give me leave to mention, my lord. My lord, this is a motor vehicle appeal.
What is it, sir?
My lord, it is my lord,
You want it to be listed?
No, my lord. It is judgment not uploaded, my lord.
Okay, give.
November 2024. May I permit it to mention?
এগুলো এখন তো এদেরকে বলা যাবে।
Mention group 6 hearing matter.
Have you served notice?
No, my lord, there is a direction of the division bench, my lord, and order was passed on 14th of August of this. I annex the order with this.
What do you want, sir?
For
As
this-
we are running late today.
Division bench has passed directed the single bench to dispose it of within 30 days, matter.
Within 3 days.
30 days within a month. And there is an order from Honorable Justice Sujoy Pal and Honorable
But I don't. What is the number of the writ petition?
I have written in that. But kindly come page number 5. Second last paragraph.
Next.
For inclusion.
That may I mention that couple of claim cases, those who had mentioned before your lordship, earlier lordship, for inclusion in the list lordship.
Next.
Application.
When did you mention it earlier?
On the last week lordship.
Which week? Which date?
Date lordship.
Nothing is there.
And on 15/5/2005, I have mentioned the notice to
দেখুন আপনার রিকুইজিশন পাঠিয়েছেন।
I have gone through the diary and
Okay.
for correction.
Well, some corrections.
Formula
When was it dismissed?
it was dismissed in notes. First of May 2010.
You settle the issue with the department first and then come. Ashun. Let the matter be adjourned for the day. You have filed an application which doesn't tally with the record. Next.
And for the appellant, my lord.
This matter has been listed at my instance. I
Yes,
have
sir.
filed an application for withdrawal of some amount. Therefore, this matter
My
has
lord, there is condemnation of delay application is still pending.
Hmm?
Condemnation of delay application is still pending.
Condonation of delay
still here.
on your side.
Yes, 6 days only. 7 days. 7 days delay. It appeared several times, they did not appear. That is why it could not be taken up.
They did not appear. That is
Yes.
why your
In spite
petition
of
for
service of notice.
5 days.
It was
delay.
fixed for some date, but on that day matter did not appear. Since then it has not appeared.
2 and 3. Who will prepare the paper book?
My lord, he will prepare.
No, I shall not. He will pay. He is the appellant, he is the.
You will file the paper book.
May prepare.
No, I'm the report.
The paper book is to be filed by the learned advocates representing either of the parties positively on 23rd of September. If you are so eager to withdraw money, then use the paper book. Next.
Since he is the appellant,
Sir, there are
but my client is not in a position.
paper. I said either of the parties. Next.
No, why not can you direct them to prepare the.
To face the consequences. Next.
Red Bull একটাই যেটা, তাই তো?
My lord, I am for the appellant. There is a CAN 2 of 2023 amendment application, my lord.
For what?
That, my lord, I earlier in other matters also have done, my lord, Bharti AXA name will be changed to ICICI. Bharti AXA name will be changed to ICICI.
When did you file the application?
My lord, I filed the application on 29/9/2023.
Which court?
654.
They have not received it. The department is directed to place a case record of CAN application being 2 of 2023.
2 of 2020.
2023 along with that of the main appeal on the next date of hearing. Next date be fixed on 1st of September.
My lord.
Next.
Appearing for the claimant principal insurance company. Lordship, kindly accept my paper book that I have served upon Mr. Singh.
Paper
Lordship, the
book filed
only
by
issue of
the,
quantum.
learned advocate representing the appellant claimant, serving a copy of the same upon the learned advocate representing the respondent insurance company be kept on record. Now tell me, can it be disposed of?
Can be disposed. Only issue of quantum. This is my appeal. Only issue of quantum.
Next date be fixed on 18th of November for orders.
Lordship.
Next.
Item number 5, Lordship. Lordship, here I am for the appeal in this case, Lordship. There is some delay. Lordship, kindly condone the delay and
How
Lordship.
many days delay?
Dear Lordship,
It is a defect pointed out by the stamp reporter. You remove that and come. The learned advocate representing the appellant claimant is to remove the defect pointed out by the stamp reporter prior to the next date of hearing. Next date be fixed on 8th of September. Next.
Item number 6, Lordship, I am for the claimant respondent. Also, I have prepared an appeal. Okay, let me see. Possible, Mrs. Suchorita Paul is appearing for the respondent, also appellant. So this is these two appeals.
The learned advocate representing the appellant and the respondent claimant is present and appear to represent the appellant insurance company. Let the matter be adjourned for the day. Next.
My lord, I am for the respondent claimant, my lord.
My lord, I am for the appellant, my lord.
Yes.
My lord, I am filing the paper book. My junior is handing over the paper book today, my lord.
You have not filed the certified copy.
My lord, certified copy is there with my junior, my lord.
So the certified copy will be filed here in the court.
My lord, it is as your lordship directs. Sometimes the court it is handed over in the court, my lord. If your lordship directs, I'll file it in the
File
department.
it in the department so that the department can.
My lord, as your lordship directs, my.
There's a delay.
My lord, delay has been condoned, my lord, by order dated 11/7/2024, my lord.
The learned advocate representing the appellant insurance company is to file the certified copy in the records of the appeal at the department for proper assessment of number of days delay in filing the instant appeal. Next date be fixed on 9th of September. Next.
Grateful, my lord.
আগে করে আনো।
I am for the appellant.
I am for the respondent insurance company.
Condonation of delay. The delay of 119 days according to me. Also, can you condone the delay? And I have already prepared the paperwork that I have served upon Mr. Ganguly.
I have received it.
19 days. Paragraph 5. Next.
Also, I am filing the
The
paper.
paper book filed by the learned advocate representing the appellant claimants we kept on record. A copy of the same has been served upon the learned advocate representing the respondent insurance company. Next date we
Only issue of quantum. This is also
19th of November.
19th of November. I am blessed.
Next.
Appear for the appellant petition appearing for the first time, my lord. Deposited the statutory amount.
4 weeks to deposit the balance amount. You did not say there's a delay.
I have filed a CAN application. There is a CAN application, CAN
So
2.
who will say that?
Okay.
Who will say that?
There is a CAN application, my lord, for condonation of delay.
Four and five paragraph. এটার হয়ে যাওয়ার পর তারপরে 4 weeks to deposit the balance amount.
GPW.
You serve notice, file affidavit of service, next date 20 November.
My lord, I am for the respondent insurance company.
Your Honor, I am on the behalf of the petitioner. My lord, I'm on behalf of the petitioner. The senior was not able to come today due to some family medical emergency. So I am seeking 1 day of accommodation.
রেকর্ডটা দেখি ডিলে আছে না The learned advocate representing the respondent insurance company is present. Who is the advocate on record?
Advocate Avik Sarkar.
Let the matter be adjourned for the day. Next.
There is a delay of lawsuit 67 days. There is only issue of one-time lawsuit.
Paragraph 5. Paper book.
Paper book lawsuit I am filing.
Paper book filed by the learned advocate representing the appellant claimant be kept on record.
On the issue of quantum lawsuit.
You have received the copy of the paper
Yes.
book. A copy of the same has been served upon the learned advocate representing the respondent insurance company. Let the matter be fixed on 21st of November for orders.
Earlier matter, item number 8, lawsuit directed for orders lawsuit.
Which one?
Item number 8, lawsuit not directed for orders.
8.
8.
Where is your other side?
Mr. Ganguly as well as you can fix it on 19th fix.
Now, how can you say
Only issue of quantum. I have submitted the issue of quantum. Kindly lawsuit.
you ask, call him then?
I will be.
Next.
Not the similar appeal.
Out of the same award pending before the by the insurance company, and on 8th of on 20th of August, you know, directed to tag this appeal with that appeal. So I mentioned the appeal earlier, not the matter has come to a list.
There was an order to that effect?
On 20th of August. In that, not in that file, in another file.
In another file. Then why are you stating this?
To tag the appeal with this. In the insurance company appeal not to pass the order to tag this appeal.
This appeal is to be tagged with another appeal.
Yes, 20th appeal file was separate appeal file by the.
Now tell me which is the date fixed for that?
Fixed on my lord. 18th 11.
18th?
11. 18 November 2020.
What is the number of that appeal?
Number of FMTM is
let the matter be
1 of
tagged
2025.
along with the case record of ওই নাম্বারটা দিয়ে arising out of the same accident.
Same accident.
Since the appeals as aforesaid arise in connection
Same
with
award.
the same accident and the identical judgment. Same judgment. Same judgment. Let the matter be fixed on which date?
18th of November.
18th of November. Next.
But 14, my lord, I need to appeal for the appellant. On the last occasion, my lord, I had indicated two defects. One is, my lord, this need not be tagged with 13. 14 need not be tagged with 13 because it arises out of completely different proceeding. And the second is, my lord, 14 arises out of an order refusal of ad interim injunction. So, my lord also does not have jurisdiction. I mean, determination. So, my lord, 14 has to be detagged and then released by your lordship.
Your Lordship,
The
I'm
learned
appearing.
advocate representing the appellant. You are the appellant in 243.
Your Lordship, I'm appearing on
appearing,
behalf of the appellant
for
in
the
item number
appellant
13.
in FMA 243 of 2025 submitted that the case record of the aforesaid appeal has been inadvertently tagged with the case record of FMA 613 of 2025 being distinct in its cause of action. The department is directed to detag the records of FMA 243 of 2025 to be placed before the appropriate bench.
My lord is also releasing this matter.
What did you hear, sir? I said to be placed before the appropriate bench.
Regarding 13th,
Item 13, my lord, this matter, my lord, your lordship, my lord, the paper book is ready.
এটা record কোথায় 13 এর?
The paper book is ready, my lord. I'm serving. I'm filing it here in number.
একটা কপি দেন, একটা কপি।
একটা copy?
दो वॉल्यूम।
Two volume.
एक कॉपी दो ना यार, तो JK।
2 volumes.
Oh, 2 volumes, sorry।
Lord, I'm giving copies to my learned
The
friends.
issue
my lord.
here.
My lord,
My lord,
this is with regard to, my lord, enhancement of the compensation and for disproportionate, my lord, award which was passed. My lord, my clients have not
Is
been.
it a motor accident
Yes,
case?
yes. And also, my lord, we have.
Enclave Private Limited and others.
owner of the vehicle. Respondent number 1 is the owner of the
Who
vehicle.
is appearing for the owner?
Nobody.
Owner, no. Even on the last occasions, nobody appeared.
Are you appearing for?
Pro forma.
My lord, the mother-in-law, the appellant is the, my lord, the widow.
They have filed a separate appeal which was.
Tell me.
Yes, ma'am. The mother is, I appear for the widow, who is the appellant, but there has been an award, my lord, in the claim case where a disproportionate award has been passed against my client. That is my first ground of challenge. The second ground of challenge, your lordship, is, my lord, the income tax returns of the correct
Mother-in-law in the sense mother of the
mother of the
victim.
deceased. Yes.
Mother of the
My lord, may I? My lord, in this case, my lord, an award of 1 crore was passed in favor of widow, mother, and the daughter of the deceased, child of the deceased. My lord, today before your lordship, my lord, the widow and the child are today before your lordship. My lord, they pray for, my lord, one is enhancement of quantum of compensation. And my lord, the widow says, my lord, that out of this 1 crore, a very paltry sum was awarded in her favor and the rest was given to her child and to the mother of the deceased. This is the 2 point in which my learned friend is aggrieved and he's today before your lordship.
Okay. But only one humble submission, my lord. We have also taken out an application in the nature of, my lord, Order 41, Rule 27 for disclosure of certain additional evidence. My lord, why I say so, my lord, why we had to disclose it now in the appeal is because, my lord, one of the grounds on which, my lord, the my claim was not fully allowed was that the income tax returns of the deceased, my lord, was since it was filed after his death, so there was no corroborative evidence. This is one of the grounds. So, my lord, I have now disclosed the corroborative evidence of certain other, my lord, entities from which the deceased received the income. So, my lord, in the deceased's income tax returns,
You had been a salaried person.
no, he was a businessman, my lord, who was a partner in certain other partnership firms where he had businesses.
So the
Those
presence
partnership
of
firms,
owner is required.
No, my
no,
lord,
no,
not in
really
this
not
case.
required.
Aditya.
My lord, can 2 is, my lord, the order 41 rule 27 application for additional evidence. But I am serving it on my learned
Paper book filed
senior
by
friend
the
appearing
learned
for, my lord,
advocate
the
representing the
pro forma response.
appellant.
The other one.
You are the appellant claimant number 1.
Yes, my lord.
No,
1 and 2 both.
1 and 2.
Can to कहाँ मेरे को दिया है क्या?
Be kept on record. A copy of the same had been served upon the respondent insurance company. You are the respondent number
3.
as well as the respondent number 3.
Who is the claimant, who is also one of the co-claimants.
The learned advocate representing the appellant claimants submitted to have filed a CAN application being
CAN 3 of 2025.
CAN 3 of 2023.
2025.
2025 for adducing additional evidence.
And two both.
CAN 2, I'm sorry, not CAN 2. CAN. My mistake.
Next date be fixed on 14th of November for further hearing.
Great.
You have served the copy of that CAN application upon them?
Yes.
तो तो नवंबर ना?
I know 8 for
For orders?
For orders.
Sure.
Yes, your lordship.
আচ্ছা ওই 8 এর যে ডেটটা দিয়েছেন 8 নম্বর given
19th of November.
you other
Deeply.
Well, in these matters, I beg to appear for the respondents.
Yes, madam, you had to file some.
My lord, it was filed, my lord. A translated copy of the SOP, my lord. It was filed. Filed for those were in Hindi, my lord, your lordship's direction.
Yes, sir. What is your matter?
My lord. To recapitulate your my lord.
This is of 2008.
My lord. Your lordship has been.
So the grievance still persists.
My lord.
Dismissal from service.
Yes, my lord.
CISF.
Yes.
Dismissal from service, my lord. Later on, it was compensated with compulsory retirement from service.
My lord.
Anyway, let him submit.
Your lordship was pleased to hear this matter extensively earlier. I am for recapitulate my lord. Kindly come to page 7 of the report.
Page?
Page 7. My lord,
At last, she has come.
This is my
I apologize, my lord. I had some issues I will still sometimes.
Yes, tell me.
My lord, this is a, I will pray, my lord, this is a case of no evidence. Reports are far. Kindly page 7, paragraph 11.
Yes, it's already marked.
My lord, I said, my lord, that the petition during the inquiries are recorded the statement of Sri C.B. Sood, Chief General Manager, who is one of the complainant. But said prosecution was not produced for examination, but the petitioner for which is filed prejudice. However, in recorded statement of Sri G. Sood, he has stated that he reported the matter on the basis of information received from N.K. Bagri. Well, this is here's evidence. Next, my lord, paragraph 12. The petitioner said that the N.K. Bagri, Deputy Chief Sales Manager, in statement stated that he reported the matter on the basis of information received from some G.S. Misra. Number 13, my lord, said G.S. Misra stated that he has reported he has received the information.
Whole matter. According to you, it was stolen.
Yes, my lord.
Beyond the premises.
My lord, that I will file supplementary affidavit, my lord, today. That I am stating, my lord, there is a wall between my duty place and where the recovered, that is labor only. In between, there is a wall. I am filing supplementary affidavit.
আমাকে একটা কপি দিন স্যার আমাকে একটা
Sir, I have recollected. Yes,
My lord.
madam, what do you have to say?
What I beg to submit before your lordship, my lord, there is a provision under Rule 54 for filing revision before the revisioning authority, my lord. That was not done, my lord. This is one, my lord. And
That should have been told at the initial stage, my lord. They have allowed the petition to be admitted. At the admission stage, they did not say.
Sir, let her submit.
And my lord, as far as this
According
person,
to you, they should have resorted
my
to
lord, revision,
review,
my
process of review under Rule 54.
under Rule 54.
They should have
Filed
accessed Rule 54, right?
My lord, my lord,
Yes.
my lord. And my lord, this lady before this petitioner before your lordship, Shivani Baske, she has come up before your lordship, my lord, after the demise of her husband. Now, my lord, she is claiming all the benefits under the died in harness category. Now, my lord, with all humility, I beg to submit, my lord, that it was communicated to her by the department concerned that since it died in harness benefits under the died in harness category can be given, my lord, extended only when the employee dies while in service. That this was not the case, my lord. Particularly in this matter, my lord, I beg to submit, because that the husband of the petitioner had died long ago, and it was not a case that he died while in service. He was removed from service, and thereafter the appellate authority had after considering the facts and circumstances, he converted it to this compulsory retirement from service with 2/3 pension. So, my lord, particularly in this matter, my lord, apart from the revisioning, apart from taking resort to the revision provisions for filing revision, I beg to submit on this count
Review or
also.
revision?
Revision, my lord. Revision.
Then you said review?
No, my lord. Revision. I apologize. Revision.
Yes.
And so, my lord, in this matter, in particularly in this matter, in the first matter, my lord, this is that she is claiming benefits under the died in harness category. With all humility, I submit. This is my humble understanding that she cannot.
What about the others?
And the others also, my lord, those persons they were not in service, but they have come up themselves, and
not in service means after dismissal.
After dismissal. They are also, my lord, they did not take
Prefer revision.
for revision, my lord. Did not prefer revision, my lord.
Yes, sir. Anything else?
My lord,
And this
so far revision is concerned, my lord, at the admission stage to tell, never they have said. Now at the so many years, they cannot raise this issue. This issue should have been they have allowed the writ petition to be admitted and heard on affidavits. Your lordship is hearing the matter on affidavit.
Revision opposition দেওয়া হয়েছিল
I have submitted, my lord, the written notes of argument also.
The opposition দেওয়া হয়েছে কি revision আছে
হ্যাঁ দেয়া আছে পজিশন দেওয়া আছে
পড়ো একটু বার করো তাড়াতাড়ি
Okay.
As regards the supplementary affidavit, I've got it today only. I don't know what is.
He had submitted an earlier note,
my lord,
and he has improved on it. It has got nothing to do with the pleadings.
My lord, grateful, my lord.
Hearing concluded, CV. Next.
Deeply obliged, my lord.
For my lord, I am for the petitioner.
Miss.
Well, this is a case against the unauthorized deduction made by the Kolkata Port Trust. Fact is this: the husband of the petitioner was an employee under the Kolkata Port Trust, appointed in 1999. But unfortunately, during his service period, he died
in 2001. After his death, the petitioner made application to the authority concerned in respect of death cum retiral benefit. They released the death cum retiral benefit, but deducted 78,000, more or less 78,000, and also told that 40,000 will be deducted from the pension, monthly pension. My lord, several requests are made. Under what provision they have deducted? They verbally told that the court case was there against the petitioner. Also said that the husband took money from the money lender after his death within 2 years in service. He took loan from the person concerned. And after his death in 2002, the suit filed before the learned court below and got degree ex parte without any notice to the petitioner. The petitioner requested to supply the relevant documents, but they refused. Against that, the petitioner moved this honorable court. When this honorable court was pleased to direct the chairman of the Kolkata Port Trust to consider the representation made by the petitioner within certain period and pass a decision order and communicate the same. That was done. But from the reason order, it was found that from unauthorized occupation of quarter, which was already cancelled. Quarter was not given, but money was deducted near about 18,000, and rest 60,000 was deducted from pensionary death cum retiral benefits as court case. When this honorable court, your lordships, pass order directing the Registrar General to serve notice to the person concerned, but they failed to locate the person. Thereafter, this honorable court, my Lord Justice Aniruddha Bose, his lordship then was, on 5th May 2011, pass an order, if your lordships, 5th May 2011.
Yes.
Ultimately, after failing, the lordship directed the commissioner of police port to make an inquiry and submit a report before this honorable court.
Yes.
But thereafter, a matter appeared once from pension, that money was recovered and she is getting regular pension.
No, what was the inquiry report of the Deputy Commissioner?
My lord,
Port, Kolkata Police?
that my lord, not, that is beyond my knowledge. Though I have also made
So this is the order of 2011.
lordship. I have also sent the order.
But
and
the
also
matter was fixed under the heading for orders on 15th of September 2011.
lordship.
So it was not, you were not there.
Not there. This is the communication. I have also communicated the order of His Lordship on 11th May 11. It is, my lord, very surprising. The person worked only 2 years. In the meantime, he took loan. And after his death, he did not know any about the same.
Hey, Aditya. I have asked somebody state to be present.
এই তোমার কাছে তো পয়সা দাও যেটা শুধু পয়সা দিয়েছে বিরাট প্লট
of increments for 6 months. Now in 2003, final order was passed. My increment for that year was not given. My career advance was deferred for 3 years. Where is the law, my lord?
So you have obtained the service book?
Yes, my lord, I have annexed one document my lord, from the service book at page, my lord.
And now he is handing over this.
At page 7, annexure
এটা তোমার,
R1.
এটা তোমার, এটা তোমার, এটা তোমার।
So in paragraph 18 of the writ petition, my lord, he has admitted that he has got the benefit of
yes after 3 years. Why, my lord?
Different thing, but he has accepted. And my lord,
That is the
accordingly, my lord,
subject matter of challenge here.
now if he wants to dispute it about the calculation, fixed
No, I am not
he
disputing.
shall have to, my lord, make a fresh representation before the authority concerned, giving his calculation.
That is not my grievance. My grievance is that I was punished. I was awarded punishment
Both
of
of you
your
can't
censor.
say at the same time, sir. At the same time, if both of you speak, it becomes difficult. Yes, tell me.
My only grievance is that the minor punishment was given, minor punishment of censor was awarded to me.
Yes.
Following a departmental proceedings. And for minor offense, the only punishment is withholding of increment for maximum 6 months. 2003, the final order was passed. I was not given increment for that year. My career advance was deferred for 3 years. 2006, I was given the career advance. So where is the law, minute? Why they deferred the career advance and minute, they withheld the increment for that year? Withholding of increment for 6 months. That is the punishment, maximum punishment for censor. That is my grievance.
Did they mention it in the order?
Lordship,
Did that?
I preferred appeal. Appeal was rejected. Yes, 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 yes.
Sir, I'm asking you, did the order imposing the penalty?
I am not challenging that.
Please
Yes,
bear
yes,
that
yes, yes.
patience to at
Yes,
least
yes, yes.
hear out the sentence. Did that order
Yes.
imposing censure
Yes.
or remarking censure mentioned that your salary would be withheld for a particular number of
no,
months?
Your Lordship, kindly have a look to P3 and accept P3. That is the final order.
Page?
Page 19. Bottom portion, my lord. The operative portion of the order. Ordered that he be censured and to be warned to be more careful in future. Also directed that he must try to achieve average notice rupees up to and such and that there is no question of withholding of increment or deferring of the career advance. That is the operative portion of the order, final order.
Later.
Yes. So for how long your salary was withheld?
For a year's not salary was my increment was withheld. No, my increment was withheld for 1 year, and my career advance was deferred for 3 years. That is my grievance in this.
Petitioner.
But you are not disputing this annexure R1 to
R1.
Get a calculation to this.
I am not on calculation, my lord.
You also
you're not on calculation.
No, no, no.
18 of the rate petition.
It is their calculation. I don't defer.
Now, subsequently, did you reimburse him?
No, no.
No. On the basis of the fixation, my lord, he enjoyed his salary. There is no dispute. His contention is this: the career advancement scheme, the benefit was to be given in 2001. When, my lord, there was the disciplinary proceeding was pending. It was culminated into, my lord, the order of punishment in 2003. My lord, because of satisfactory service, my lord, the cash benefit or promotion is given. Since, my lord, there was pendency of disciplinary proceedings against him, he was succeeded. My lord, the audit, my lord, cancelled the, my lord, the grant of benefit, and my lord, accordingly, my lord, the grant of benefit was deferred, and he was given, my lord, in 1st July 2026. After 24 June.
So this order was issued on which date? Order of censure?
24/6/2003.
24/6/2003. And you superannuated on, or you are still in service?
I will be superannuated in December.
This year.
So in this period,
Yes.
had there been any complaint against you?
No.
Any further proceedings? আসুন।
ওটা minor question, minor.
The
Lord,
Was passed on, supposed to get it in 2003.
copy of the service book.
I want to deny another document, my lord.
Which document?
My lord, it was clarified by the managing director that the due date would be date when an employee gets 10th annual increments, 20th annual increments on completion of 10th years of 20 years of service. And next, my lord, in case of censure, the date would be deferred as per promotion norms till 3 years of punishment of free service is rendered by the employee.
So it's where is it notified? देखिए।
Then, my lord, accordingly, my lord, he was given from 1st July.
Circular.
যেখানে লাল কাজ ছিল না কোন জায়গা থেকে হলদে করে যাচ্ছে the first, fourth, and fifth.
Did you annex this with your affidavit in opposition?
This was not annexed. But I have mentioned in the affidavit.
Then why didn't you annex it? You should bring it on record in the form of an affidavit. Take it দিয়ে দিন। The copy of the service records in compliance with the order dated 6/8/2025 passed by this court has been filed by the learned advocate representing the respondent CSJC through an affidavit. Let the same be kept on record. A copy of the instant same had been served upon the learned advocate representing the petitioner. What will you do, sir? You will file this in the form of an affidavit? The learned advocate representing the respondent See, let them file it because
the petitioner is to return on 31st December 2025, this year. So you'll
okay, prior to that, yeah. CSCC is to
petition.
file an affidavit annexing the documents relating to the circular as placed before this court today. On the next date of hearing.
Regulation is otherwise, my lord. Regulation is otherwise. Regulation does not say that can be deferred. The only punishment is censure and for withholding of income.
12th of September, sir, you file it. Next.
23rd.
Before my lord, I am appearing for the petitioner.
Sir, what is the fate of that criminal proceedings?
My lord, it ended in dismissal. He came to this honorable court. After this honorable court,
No,
he
sir.
is
There
reinstated.
was a case being numbered 57/91 registered against him under section 385/170 and 171 IPC. That's been in, you have mentioned it in paragraph 3 of the petition.
But that order from the criminal case, he was acquitted. He was acquitted.
So that order of acquittal,
But at that time, it was dismissal from service. Then he came to the honorable court. This honorable court was pleased to quash the order of dismissal. Then he was reinstated, but entire period was treated as not on duty and without pay. Again, he came to the honorable court. This honorable court pleased to direct that he is entitled to salary for the entire period because for his no mistake, he was dismissed from service. Thereafter, my lord, salary for the entire period has been given. Now, my lord, remains that for one day he was in a mess and he went to for purchase medicine, the police arrested him. That day he was soon absent, and for that day, a punishment remaining, stoppage on increment with cumulative effect. Now that is under challenge, my lord. When the period has been regularized by salary, he is no longer absent. He is no longer accused. How the punishment comes out? This punishment, my lord.
who was appearing on your other side?
My lord, come on, appear, my lord. Just
So can you come at 2 p.m. today, 2 p.m.?
my lord.
Okay. Hey, Aditya. Next. দুটো না তিনটে নাম আছে যে যখন পারে আসে।
What is that? My lord, I am for the petitioner. My lord, on the earlier occasion, my lord, the participant, my lord, the petitioner, who has participated in a interview for the Home Guard, was somehow disqualified. Thereafter, my lord, he was absorbed in a, my lord,
affidavit in
post of-
opposition to the supplementary affidavit be
post
kept
of
with the record, my lord.
civic volunteer. If your lordship takes up my affidavit, my lord, where, my lord, she has categorically stated that, my lord.
When did you file it?
হ্যাঁ, এক মিনিট। Affirmed on 14/12, page 4.
Which year, sir?
2023. No. It has been affirmed on 21st April 2025.
দিয়েছো তুমি?
হ্যাঁ হ্যাঁ হ্যাঁ,
কবে দিলে?
ভাবেই করে রাখে।
না, তারপরে আর হয়নি মনে হয়, দেখো।
তারপরে হয়েছে। একজন।
এই, দেখো তো মনে হয় আগের দিন তো একটা লিস্ট এলো ভুল ভুল নাম্বারে।
না না, তার আগেই তো জমা হচ্ছে।
যেটা
না না না,
বলো। হয়নি, ম্যাটারই হয়। লাস্ট অর্ডারটা কি দেখ? Your Lordship, on the last occasion, was pleased to direct my learned senior friends appearing on behalf of the state respondent to produce the entire records of the selection procedure.
Milord, the question of records come later, Milord. She herself, while joining in the service as a civic volunteer, declared that the above information furnished by me is true to the best of my knowledge, and I do hereby voluntarily
Served with a copy
give
of the affidavit in opposition.
But have a supplementary affidavit they have served, and I have filed my affidavit opposition to the supplementary, which is filed today, my lord.
that I shall have no claim for any full-time engagement or any other permanent employment with Kolkata Police in future. I also declare that I will render voluntarily service on purely no work, no pay basis. Page 7 of my supplementary affidavit.
No, where is the case record? I mean, the record of the selection process.
Milord, the details of the selection process, Milord, is with me. But Milord, the office in 2020 was shifted from R.N. Mukherjee Road to the Bodyguard lines. And Milord, the actual records, Milord, at that point of time, Milord, the computerization and digitalization was not that, Milord, in use. So, Milord, these particular records of all the participants, Milord, could not be traced.
File it on affidavit, it could not be traced.
My lord. But my lord, for the time being, my lord, may I be
You
permitted
file an affidavit.
place my procedure, my lord, through which all details are there, my lord.
You are referring to the affidavit in opposition, but it's
My
not
lord.
on record.
তাহলে এটা কোথায় গেল?
affidavit.
Supplementary affidavit.
That is not in record. আমার মনে হয়
না
একবারে
না,
হয়নি।
জমা করেছি, হ্যাঁ জমা করে পড়তে অ্যাডজাস্টমেন্ট করে জমা করে
কপিটা দাও দর্শক কি এমনি।
আর আমি একটা এমনি কপি দিয়ে দিচ্ছি একটা।
If this is their only ground,
No, and one more thing, my lord. In the advertisement, it was stated, which I have also mentioned in my affidavit, my lord, that any
You had filed the opposition prior to 2024.
No, my lord, no. This I have filed. This was been affirmed on 21st day of April 2025.
but
You are representing respondent number 11 to 13.
oh, he is representing the state.
State, seven.
The state. I am for
Only the state.
I am for the private response.
So did you file your did you file the
Yes.
affidavit in opposition? You have filed.
11 to 13.
But on the last
Order to
occasion, or
No, there's an order. They have
there's
filed.
an order when they wanted to produce a document.
No.
Lordship was pleased to direct them to file it through affidavit.
No, my lord. The order had two parts. One is to file an affidavit, and the second is to produce the document.
That's the last order.
সেদিনকে আমি ওটা তো ফাইল করা
There
হয়েছে।
যা হয়েছিল তারপর তো ভুলে
না, ফাইল করা হয়েছে। তাহলে আমার
এসেছিল।
জুনিয়র কোথায়?
তোমার
No,
junior
you
কোথায়?
have not filed.
জুনিয়র কোথায়?
You haven't filed.
there was no scope to file. Because
The date
thereafter
was
the
given,
matter-
but that on
yes,
that
the
date,
order
you
was
did not
there, but
file.
Thereafter the matter was not
তাহলে
taken up
junior
even.
কোথায় গেল? রেজাল্ট বলছে?
And if your lordship
might be
can
with
hear
him.
me,
Confused.
they are relying on a document which has been signed by allegedly signed by my client.
What allegedly?
The year
Let him
20
deny that it was not signed by
No,
her.
I'm not
First of
denying,
all,
I'm
you
not denying.
get the affidavit in
2023.
opposition on record, sir. It's
My lord.
Matter is of 20.
Supplementary affidavit. Supplementary affidavit.
no affidavit in opposition also.
They have filed already.
Opposition we have filed.
Opposition
Long back.
they filed long back.
Long back.
This is the new affidavit of
সেটাই
supplementary
চাইছি।
affidavit.
No.
This is a change brief. Opposition has been filed long back by my predecessor advocate.
You are representing whom?
State.
That is respondent number?
7.
Then তুমি 12, 13 দেখতে পাচ্ছি। 12, 11. Their opposition কোথায়?
ওই রেজাল্টের কাছে রয়ে গেছে।
Supplementary affidavit file করতে থাক।
এফিডেভিটটা জমা করেছিলেন সাপ্লিমেন্টারি এফিডেভিটটা? সাপ্লিমেন্টারি এফিডেভিটটা কই? কোর্ট রেকর্ডসে তো নেই। নেই মানে আপনি কি জমা করেছিলেন? শিওর? আপনার ব্রিফ কোথায়? আরে আমার এখানে হাত দিচ্ছেন কেন? আপনার ব্রিফ কোথায়? এরকম হয় নাই কখনো।
No, it's not there on record.
খেলা নাকি এটা কোর্টের সঙ্গে?
There is no scope. There was no scope to file because the when the last order was filed, thereafter the matter is taken up today. Therefore, we have exchanged, but we could not file.
Neither the copy of the supplementary affidavit nor their affidavit in opposition.
Opposition of the private respondents.
No, state.
State has filed me not long back.
Yes, that is there, but I have seen the records.
এটা বারবার দেখতে চাইছি
পরে পর
না পেছনে নেই বলে
আরে দূর আপনি করেছেন কিনা বলুন।
আমার মনে হয়
state supplementary affidavit you have not filed.
Not filed.
That copy has not been filed. You must have been served with.
I have been subbed with the supplementary affidavit and I have
But
also
they did not file it.
I was under the impression that it was filed
No.
by my learned junior. হয় নাকি এরকম করে আবার? And Milord,
file না করলে আমি
Sir, if you don't produce the records of the selection process,
my lord.
then you will have to file an affidavit to that effect that you
To that
cannot. Yes,
It is
that
in
you,
the opposition
you have
will,
failed to trace out the records. File it. Ashun.
well, my affidavit in opposition to their supplementary affidavit.
Sir, first of all, let
Okay,
it
I'm
be
keeping
on
with me.
record.
I'm keeping with me. Let them file. But it's a matter of 2012, my lord. I'm suffering, my lord.
She is working. She is working.
I'm not denying that.
She
This
is
is my
working.
statement.
She is working in the post of a civic volunteer with a specific undertaking that in future she will not
Absolutely,
apply.
I deny
She will not
absolutely.
apply for any government post under the Kolkata police.
When?
So it is not the
2023.
fact
And
that
my matter is
she
of
is unemployed.
2012.
She is working, Milord. She is working, and she
She
has
is
been
working. This is my
disqualified in
statement
the
in my
interview.
petition.
She has been disqualified in the
So
interview.
that is why I had
My lord,
asked
my lord,
you
my
to
lord.
produce
My lord.
the records of the selection process.
And Milord, the fact is that as on date, it is not the fact that she is unemployed.
And
She
if
is
it
working
was
very
so
much.
urgent on your part, after filing the writ petition, why didn't you take steps to expedite the
The
hearing?
matter was taken up several times.
Then
only one day I
Because she is in
thereafter my lord
service.
is taking
She is in service, Milord, with a specific undertaking
So what? So
that
my-
while joining the
now
service,
I don't have time to listen to both
My
of
lord.
your copy of the supplementary affidavit as well as the affidavit where you state that you
Stating.
have failed to trace out the records pertaining to the selection process. Right?
my lord.
Heard the submission of learned advocates representing both the parties. The learned advocate representing the state respondent submitted that in compliance with the order dated, which was the date of the order, where you had been asked to, পুরো রেকর্ডটাই নিয়ে চলে গেল।
Order dated 10/3/2025, I think.
Yes, yes.
Huh?
10/3.
10th of March.
10th of March 2024. 5.
কি বললাম জানো? 10/3/2025, the the records pertaining to the selection process held in the year 2012 in respect of appointment of lady home guard volunteers in Kolkata police could not be filed as the same could not be traced out.
The affidavit is dated in connection with a declaration, but as far as
Whatever it is,
the records.
the learned advocate representing the state is to file the supplementary affidavit as well as of a further affidavit stating their inability to produce the records as aforesaid, which according to them had been untraceable.
My lord, I am for the private respondents, my lord. May
Yeah,
I
the
get a
learned
copy of the
advocate-
affidavit used by the state?
Let them
Supplementary-
file, sir. Let them file. Representing the private respondents.
Private
is present. Next date we fixed on 18th of September.
Milord, kindly takes it after vacation, Milord.
No.
Milord, we have to make one more effort, Milord, to trace out the files, Milord.
Will not. You have been given sufficient. Next. Either you are reluctant
Milord.
or you are
The office was
negligible,
shifted, Milord.
or you
The
are
the file has been missed during that time.
Yes.
Grateful, my lord.
46. But now if they have missed the file, from where will they retrieve the file?
No,
According to
Milord, I was just trying to
just ask them.
possible. Milord.
The petitioner, I am for the petitioner. I am led by Mr. Dinabandhu Chaudhary. Kindly see last order, 20th May. Private respondent have to file their opposition. My lord's direction.
Yes, where is your opposition for affidavit in opposition, sir?
No, they are not, my lord. Private respondent number 5.
Then who is supposed to file?
My lord, respondent number 5. Kindly see, my lord.
We are on the 1, 2, and
Second
Are
paragraph.
they the answering respondent?
My lord, he is the claimant also. My lord, I am the wife of the deceased. My lord, respondent number 5 is the mother of the deceased. This is a compassionate, my lord, appointment. My lord, on last occasion, my lord have been pleased to give them chance to file
So
their.
if they have not filed and if they are not there, you continue with your submission, sir.
But let it fixed on any day, my lord.
Why, sir?
My lord, we think, my lord, they will file this. That's why, my lord.
You think and therefore you are not ready.
No, my lord.
So what is your matter? You so thoughtful? What is it?
I am led by Mr. Chaudhary. He is unwell.
This cannot go. Then I'll dismiss. I have given you people sufficient. You come at 2 p.m.
Mal.
You inform your other respondent friends.
Mal.
To come also.
Mal.
Next.
Well, at 48, I am appearing for the respondents.
40. Yesterday also nobody appeared.
No, madam.
Achha. The learned advocate representing the respondent state or
No, my lord, I am appearing for respondent numbers 2 to 5, my lord.
respondent number 225 is present. None appeared to This is the petitioner who appears in person.
My lord, initially he was represented by an advocate. Thereafter, my lord, the advocate was also not appearing. The petitioner appeared in person. He is also not appearing there.
Next date we fix on 16th of September.
My lord.
Next.
Well, this is that matter where Mr. Amolish Rai and Mr. Partho Bhattacharya was appearing for the petition. Today it is my chance to make submissions. I will try to narrow down the gamut of this petition. Just takes one of the petition if 20013 ota konta 49 to that is item number 49 if your lordship kindly takes that your lordship will kindly come to the press
Of the writ petition?
of the writ petition. Starts at page 29.
Yes.
The first challenge when it starts from prayer B first. Prayer A is leaf. It is a virus challenge to Kolkata Municipal Corporation Act Section 26 5B. This has henceforth it has been amended, has been repealed. So they have also not pursued their case of virus challenge. Next will kindly see to forbear and from giving effect to and of further effect to a memo of 30th March 2016 issued by the Joint Secretary Government of West Bengal. This notification is a notification by a Municipal Service Commission saying that recruitment has to be in terms of the Municipal Commission Act. What had happened, SJDA in the year 2010, had initiated a recruitment process. 2012, sorry. Had initiated a recruitment process. Now, while doing that, it continued its recruitment process. Then suddenly, they found that there is a memo of 2012 which is issued by the Urban Development Department, saying that
you can't do it.
You can't do it because it has to be through the recruitment commission. So, accordingly, SJDA fell in line, if I may say so. First, SJDA thought that because they gave a request that if this could be done otherwise, but the municipal commission and the urban department said no, it has to be done through the recruitment process through the act. So we decide on it and ultimately take a decision that the recruitment process will be initiated will not be given any further effect.
The petitioners were given liberty to appear
Now,
in the subsequent.
now, the petitioners approaches your lordship's court in several writ petitions. That's cutting the whole thing to a short point. Comes before this court and says that first, I cannot stop a recruitment process, though initiated wrongly. That was one. And secondly, in the interregnum, through the commission,
you had again initiated a process.
Another has been initiated.
And they did not participate in it.
They participated, but without prejudice.
Participated?
Yes.
Yes, there were orders of this court which allowed them to participate without prejudice and also no opening of the results. So this was the situation. Now, obviously, SJDA made a couple of vacating applications before your lordship, because obviously, because of this, SJDA's employees, the number of employees are reducing because obviously people are superannuating and there are no further recruits. So, the vacating application is made before this honorable court. Subsequently, it comes up before your lordship, where primarily there was an order passed by the Honorable Justice Shunji Banerjee's lordship then was, which said that SJDA will have to initiate fresh proceedings in accordance with law. Now, what is the meaning of in accordance with law? That is what we have now absolutely will come down to. According to the petitioner, excuse me. They say in accordance with law means I will have to look at the beneficial part of this recruitment process, and that is in accordance with law. And for my client, I will be very candid to your lordship. Whichever recruitment process your lordship says, I am ready to follow, because at this moment I am in dearth of employees. So I need people to work. But according to me, if your lordship, the legal part of it, what my learned friends are asking for is, that the SJDA is hit by the principles of estoppel.
Yes.
Because they had initiated a recruitment process, therefore they will have to give my learned friends' clients the right or the post also.
So you were appearing for the petitioners, right?
In one of the matters.
I have already
So you, the petitioners.
Yes.
They had subsequently appeared for the next stage of the examination, which was held.
With the order of this Honorable High Court, I was allowed to appear. So by an interim order, subject of decision, the final decision of this pending writ petitions.
So in that examination, which was held according to them,
Yes.
in accordance with the law.
Well, I just say my what happened. During the pending of the writ petitions, they filed an application that examination may be held through the Municipal Service Commission, and our High Court was pleased to pass an order that we held subject to the decision of this writ petition, and we will as a guardian we may be allowed to appear. So that decision is subject to
not to be published.
yes, that decision, that order is subject to the
Then maybe in some other matter, they did not appear.
could be Mr. Bhattacharya's appeal করেছিল? No,
in all the
three
matters, the petitioners appeared in the subsequent examination.
subject to a personal court's order.
Yes, that's there. I just wanted to know whether they had appeared for the subsequent examination.
I had given an easier route, I don't know why they objected to that. I had said, since your lordship is hearing, but if the results, kindly hears me out, if the results are looked into, and if they are found successful, then there is nothing left in it. But for some reason they opposed it. They are saying no, that is not to be given. But that would be an easier route. If the results find them successful, then what prevents them? They will get the job. But they are not agreeable. I thought that this would be an easier route. But since they don't want to take it, let me proceed, Now, will kindly straight away come to the writ petition, Let us see what they have, because we are bound by the pleadings of the writ petition, will kindly come to paragraph, But I'll just place a few orders, I think that would be, because we have done this matter quite some time back, so let me place a few of the orders, kindly straight away comes to, page 51 of the writ petition, This was an order passed in WP number 165 of 2016, of Justice Shonji Banerjee, at page 57, if your lordship kindly comes.
Hey, Shantanu, ও হাত থেকে ওই মোবাইলটা নিয়ে নাও। আর
kindly see 57, the state is represented, and it is fairly submitted that the instructions issued.
I have seen, I remember this.
But only thing, my lord,
Because in a similar matter, the petitioners, they themselves did not appear. So I was confusing this with this matter. In this matter,
only as a question to myself, but a query to myself also, my lord. If your lordship has already decided, then, my lord, it will be better for me to have a look into the order, my lord.
no, it's in a different matter,
Not on the same subject, my lord.
not on the same.
Oh, man, I thought that was the same subject. I'm so sorry.
It was on the ground of appointment. I mean, they wanted money. Anyway, that's
My lord, I'm sorry, my lord. My lord, kindly, I will only place one paragraph, my lord.
yes.
My lord, that is at page 58, my lord, because this is the main bone of contention. I need to show that, my lord. Because Mr. Rai has more or less submitted mostly on this. Kindly sees the third paragraph. In such view of the matter, my lord. In such view of the matter, the instructions issued thus far by the state to the SJDA as to the conduct of the recruitment process through the Municipal Service Commission, including the letters dated such and such, disclosed in the state's affidavit, are set aside. But the setting aside was primarily on the ground that the Commission Act required that a notification has to be issued and a letter has to
That
be
is there in the second paragraph.
second paragraph. So, Malad, that is what is set aside. Now, an SJDA is directed to take appropriate steps in accordance with law. So, Malad, this is the bone of contention. This is the bone of contention. Malad, Mr. Rai has made several submissions. হ্যাঁ অনেক judgment দিয়েছেন আপনি and he has referred to quite a few submissions judgments, my lord. And kindly gives me a minute, my lord. Sorry, my lord.
No,
I want to note
that process was not completed.
Yes, that process was not completed. That process was, if I may be permitted to say, not in accordance with law. Now, Mr. Rai submits, my lord, that in accordance with law,
Yes, in accordance with law.
my lord, according to him, my lord, he says, according to the law as interpreted in binding precedents. That is what my learned friend says. Now, my lord, I am only, my lord, a simple submission, my lord. A binding precedent will be one which will bind the law itself, the statute itself, my lord. So we cannot turn a blind eye to the statute and say that the binding precedent is that in accordance with law means that something which is contrary to statute will become in accordance with law. For this, my lord, he has relied on two judgments, my lord. He is saying that the expression in accordance with law as used by in this judgment, my lord, would be to protect all such employees whose appointments have been made. So he's not wanting for this. But when the judgment which he has cited, but I'll refer to that because we are nearing, my lord. There, my lord, it was specifically stated, appointments have been made in consonance with the statutory provisions or under a valid policy decision of the state government. So therefore, my lord, what I have understood, my lord, Mr. Rai is trying to place his entire case on this order of Justice Banerjee.
Second paragraph.
Second and third, my lord. In accordance with law, is the third paragraph.
No, but then if it is in accordance with law, you are acting not in accordance with law according to him.
My lord, that is what I'm trying to find out. According to him, what would be in accordance with law today? Or even at 2019, let us say.
That is 2012.
2012. In 2012, my lord.
He himself is laughing.
I know. My lord.
I'm always, my face is a smiling face, my lord.
My lord, I always have a smiling face.
I'm never angry, my lord. Angry. বল খবর
আমি রাজি থাকবো ওই শুধু এইমাত্র পিয়নের উপরে অসভ্য তুমি বলো তো
আচ্ছা
এতদিন করে এই সব করছি কেন বসে বসে
We'll continue with this tomorrow.
Yes.
Because it's going on for a long time. Let us finish it off.
Yes, my lord. But I am also a bit of a pressure, my lord, because employees are too few employees at the moment.
Now I'm staying in Shiliguri. Every day I'm facing.
Acha, heard the submission of learned advocate representing. You are representing the state.
No, my lord, SJDA.
SG.
SJDA, Siliguri, Jalpaiguri
Then,
Development.
madam, you were also
Speaks for the state. No, Municipal Service Commission.
I'm from West Bengal Municipal Service Commission.
Acha, you
মামলা তো আমি করছি দেখতে পাচ্ছি, আপনি করুন।
let the matter be fixed tomorrow for further.
Item next matter, 19.
Third,
52 mallet only for not today, my lord. I'm not.
And all three matters tomorrow, my lord.
Because mallet 2 p.m. mallet other matters is engaged. That's why mallet both parties are appear.
So then don't appear, sir, if you
Mallet
are.
with the consent, my lord. Only not today, my lord.
No, you
মানে
come at that
ওরা time
point.
fix করলেন যাচ্ছে।
2 p.m. tomorrow 2 p.m.
2 p.m. Yes.
2 p.m.
matter.
Before.
Item number 1, 2, and 3.
Item number 2 and 3, my lord, I beg to appear on behalf of the writ petitioners. I am led by Mr. Somo Majumdar. On the last occasion, your lordship was pleased to, my lord, direct us to submit a status report indicating the status of the special leave petitions which are pending before the Honorable Supreme Court, my lord, in connected matters. My lord, may I?
Has there been any progress?
So, my lord, lastly, the matter was taken up. There are two SLPs. One has been filed by the Union of India, the other by my employer, Sport Trust. My lord, both the SLPs appeared together on 21st of August, and both the matters have been directed to be listed once again on 7th of October. That is the latest.
Milord, may I say one thing, Milord? The matters before the Honorable Supreme Court is on a different footing altogether. What is pending before the Supreme Court is bunching up. And what is pending before my lord is stepping up of pay. So kindly hear out this matter. Whatever is there.
He's saying it's identical?
No, it's not. It's not identical. May not be connected. May be connected, but the issues are completely different.
But then why did you say that because of the matter?
Connected matters, my lord, not identical.
So this is for the first time you are saying this?
No, my lord. That has all along been my submission, my lord. That these are connected matters.
Well, let my learned friend start, Milord, whatever it is. Let this matter be over. Because everything is standing, everybody is standing in the queue. But I have to run the administration. This is 20.
So this was his submission on the earlier occasion.
Yes. 30th of April.
Lordship may kindly takes the trouble to look into the order dated 11th of March, my lord. I've seen.
11th of March is there.
Identical, sir.
Yes, I have a copy. I have a
11th of March, আমি দেখেছি ওটা আমার কাছে আছে। 11th of March, my lord, it was my specific submission that these are, my lord, connected matters. Lord, we do not have any difficulty in the event your lordship is, my lord, desire us to hear out the matter.
Yes. Then there is
That
no
event, my
problem.
lord,
So
lordship-
fix up a date for that
Yes.
matter.
Lordship,
Very
Because your senior is not there. He will conduct or you will do?
No, he will.
Wait, we'll keep it on a day convenient to the court, Milord. But Milord, this side of the vacation.
Yes.
At least let us try.
The earlier matter was fixed on which day? Do you remember, sir?
I think on
Appellate
20.
side matter?
Yes. The other one is I don't remember, 3rd or 10th.
September.
Yes, September.
On the prayer of the learned advocates representing both the parties, let the matter be fixed on 16th of September.
Very good. I'm grateful. Milord. Ricardo. Union of India. Yes, 24th type of the
What is the number of your matter today in today's list?
24.
24.
Lordship.
Sir, in this matter, in this writ petition by an order dated 5th of May 2011.
I've
You've seen it?
I've seen that.
Now,
Milord,
in
the-
these circumstances, for interest of justice, I am of the opinion that an inquiry ought to be made as to whether there is any person by the name of such and such.
I followed.
Such,
I followed.
right, sir?
I followed.
Till date, the order has not been complied with,
No,
and
sir.
there is no report of the Deputy Commissioner, Port Kolkata Police, to file
Give
this.
me 2
Sir,
weeks of
I
time.
will request you to take this matter
I will.
with the
I will.
concerned
I will immediately.
police
Today itself,
department
I'll take it up.
and see whether they had conducted the inquiry.
If not, it will be done, Milord.
Okay, sir.
I'll follow. Only, Milord, I will need the copy of the writ petition to, Milord, get the address and all of the
Yes.
income.
Nonetheless, the address is there in the order itself. Nand
May I-
Kishore Rai residing at 49 by
I do
5
not know what
circular.
might else be required, Milord. I do not want. May I get a copy of the writ petition?
I will give.
Anyway,
Extra copy আছে কি নেই বলে।
এরা কোথায় গেল? শ্রীমন্ত চঞ্চল। The learned advocate representing the petitioner referred to the order dated 5/5/2011, passed in the instant writ petition by the coordinate bench, directing the Deputy Commissioner, Port Kolkata Police to conduct an inquiry to ascertain the whereabouts of the person as named therein to be residing at the address stated in the aforesaid order. The learned advocate, who generally represents the state, is requested to ascertain the status with regard to the report directed to be filed by the coordinate bench of this court while order dated 5/5/2011.
Your Lordship may observe, if the inquiry has not been conducted, take appropriate steps and file the report before Your Lordship.
In case the aforesaid order had not been complied till date as far as the inquiry to ascertain the location as well as the
person
identity of the person, fresh inquiry be concluded within a period of
2 weeks, Milord.
2 weeks. Next date we fixed on 24th of September.
Well, one difficulty I find, Milord, the state is not a party. So
I know, that is why I said
Your Lordship,
requested to.
I will do that. I will do it.
It is-
Else, Milord, Your Lordship can give leave, grant them leave to amend the cost title and add state a party. That will, Milord,
But they don't have any relief against the state, I believe.
as Your Lordship please.
This is India government only.
The learned advocate representing the petitioner is to provide the details as regards the petitioner and the address of residence against which the inquiry needs to be conducted.
We are grateful.
You need not get the copy of the petition, sir.
Ah.
He will, everything will get.
Name that name and that address, 49 by 5, whatever circular road,
We are grateful. Milord.
along with the copy.
Along with the.
We are grateful.
Sir, I'll thank you on the next date.
No, we are obliged to assist Your Lordship.
Next.
We are grateful, Milord.
Grateful, Lordship.
34.
So it seems that all the names are not traceable. The
Rudrajyoti-
advocates who have lent the,
Well.
anyway, the learned advocate representing the petitioner is present. None appear to represent the Respondent Union of India. ওই যে অ্যাড্রেসটা আছে ডিপার্টমেন্ট অফ ল অ্যান্ড জাস্টিস, ওই অ্যাড্রেসে যে অর্ডারটা আছে ওই অর্ডারটা করে দেয়, ওদের কাছে আছে অ্যাড্রেসটা নিয়ে। নেক্সট ডেট we fix on 22nd of September, sir. ওর কাছে ওদের কাছে তো কি ভুল হচ্ছে, আপনি তো ভুলটাকে রেক্টিফাই করবেন এখন।
Lord, I'm for the petition. I'm led by Mr. Chaudhary is on virtual mode. Since he's ill, that's why.
Already I am for the respondent number 3 in this matter.
Sir, you are for respondent number 1, 2, and 4.
1, 2, and
Yes, sir.
My lord, your lordship directed to give a notice to the learned advocate of the respondent number 5, who is the mother-in-law of the petitioner. But the learned advocate has said that he has left the brief and no more in this matter. I am ready to proceed with this case.
Sir, their presence is required.
Yes, mainly the respondent number 5 raised objection against my claim. But his right has already been decided in this. I have annexed the order, but earlier my court was of opinion that her presence is necessary. That is why his name, her
Sir,
name
you
was
start.
added.
Thereafter, we might issue administrative notice to be served upon the respondent number 5. What is the issue, sir?
Issue is this: the husband of the petitioner was an employee under the Central Police Force who died in 2003. After death, the family pension was started in favor of the petitioner. Thereafter, the petitioner remarried in 2010. After remarriage, the mother-in-law lodged a complaint that she has remarried, don't pay him the pension, pay it to me. Now, her right has been adjudicated by an order that I have annexed that you are not entitled to get. Even after remarriage, she is entitled to get pension. Now, after that, another order has been passed in requesting the bank. The bank suo motu stopped the pension. Then another order has been passed directing the bank, no, she is entitled to get, you pay this. Surprisingly, in the impugned order that is in last page, another officer directed in 3 lines order.
Which page, sir?
Page 36, last page, annexure P4.
Yes.
Order dated May 2015, 6th May. It is the impugned order in this writ petition. With reference to the pension disbursing authority letter, such and such reply has already been forwarded to bank authority via this letter of event dated 31st March 2015, and copy of the same also endorsed to you, but it was not served, but it has been annexed subsequently. However, it is once again informed that you are not entitled to family pension as you remarried with Sheikh Khuddus Ali, whose monthly earning is higher than the minimum prescribed limit of the family pension. But under the rule, the monthly income of the wife shall be taken into consideration, not his husband. Now, can you see the very peculiar, the letter dated 14/11/2014, they are saying. But can you come to page 34? It has been finally decided with reasons. whether I am entitled to get it or not, it will depend on my declaration whether my income is increasing the limit of the pension or not. But I have given the undertaking that my income is not increasing. But under the rule, they cannot take into consideration of the income of the husband. Now, at the time of moving the writ petition, they came with another story. They handed over a copy of a letter wherein my client allegedly wrote that I don't want the pension. For that reason, the Honorable High Court directed to give opposition, and after lapse of about 9 years, they have given the opposition, and that letter was annexed in a copy was handed over. The Honorable High Court directed them to produce the original. That has not been produced. Anyway, against that letter, I wrote a letter to the authority that I had never issued this letter. Several sign was taken on blank paper. Anybody, even my mother-in-law could have done this, but I have not. Even assuming that it has been submitted, I am withdrawing it. Kindly see the date of that letter in their opposition. So far, the impugned order is concerned, it is very bad, liable to be set aside in one line, because the authority has adjudicated by giving reasoned order. If your lordship kindly come to opposition.
Yes, sir. The mother-in-law in that
Yes.
aspect is required.
My mother-in-law, my lord, is also not entitled to the pension because the income, my lord, of the mother-in-law is higher than the certificate. That I have stated in my affidavit now.
Sorry, presence is not practically not required. Her right has been adjudicated by an order that has not been challenged. That is in page 25. The order is in Hindi. I have translated in English. The letter has been sent to mother-in-law, Aura Bibi Mandal. 16/11/2013, it has been decided that you are not entitled to get. My client is entitled to get, and accordingly, direction was passed.
Who was the nominee in the service book?
Nominee, my lord, initially the mother was the nominee.
So mother is response number 5.
Yes.
5. But there is no dispute relating to retirement benefit. It will be nominee has taken everything. We are not opposing that.
Okay, sir. Okay, sir.
Under the law, nominee cannot get it. He has to give it to the person who is entitled to get it. But we are not objective.
The mother has to come and show that her income is higher
than the required pension.
Higher than the income of the present petitioner to entitle this petitioner to seek the family pension, right? This is under the rules. Okay.
No. Under the rule, wife will get, no other. There is no question of giving pension to the mother-in-law. Kindly see the rule.
Pension rules, your lordship, I have the document from the affidavit in opposition, your lordship.
They cannot say against the rule.
Why the
They have said the income is higher. But as per rule, only the widow.
Where is the rule?
Pension rules, and yes, pension rules not.
I handed over a rule earlier.
Page 12 of my
relevant rule 54.5. I handed over a copy earlier. Family pension, portion of the rule I handed over.
Page 12 of my affidavit.
And can you see page 3 of the rule? Rule 6. The period for which the pension is payable shall be as follows. subject to first proviso in the case of a widow or widower up to the date of death or remarriage, whichever is earlier. It is, my lord has got it.
What is 10A? Subject to subrule 10A in the case of parents who were wholly dependent on the government servant immediately before the death of the government servant for life.
Kindly see, provided death and the deceased government servant is not survived by a widow or an eligible a child. If there is no widow or child,
parents
parents, yes,
shall be
family
payable if the
pension-
parents were wholly dependent on the government servant immediately before his or her death.
and
The deceased government servant is not survived by a widow or an eligible child.
right? But she is not getting.
Here the petitioner has remarried.
Yes, your lordship, can you see the page 10 report? Page 10 affidavit in opposition.
Kindly see the rule 6 first for a moment.
Page 10 of my affidavit.
Page 3 maybe.
Inquiry
10.
Page 10 of Art 3 of my affidavit in opposition.
খুলতে পাবে ওইটা না রিপোর্টটা এইটা ব্রিফ নোটটা
Who is Tahura Bibi, the respondent number 5?
5.
Yes, ma'am. Respondent number 5.
Respondent number Tahura Bibi. Yes, yes, দেখেছি আমি
ওইটাই বলছি।
বলছি তো Tahura Bibi.
So is she still alive?
Is that
At that point of time, she was 80 years
80 years?
of age.
I do not know what is the latest position. Tahura Bibi. হাইবে কি আছে? Oh.
রিফিউজ করে দিয়েছেন ব্রিফ
No, in this you have, it is written, so it is established, Tahura Bibi, Bawa, age 80 years, wife from such and such,
Yes.
is the actual next eligible family member.
Family members.
Kindly see the date of this letter. 28 February
2011.
11. Kindly come to page 25 of the writ petition. Final decision, that is
See
order
first of all
dated.
whether she is still alive or not. Okay.
কে বলবে সেটা?
Page 25.
No. Heard the submission of the learned advocates representing the petitioner as well as respondent number 1, 2.
1, 2, 4. 1, 2, and 4.
1, 2, and 4. None appear. The learned advocate representing the respondent number 3 state.
I am for the State Bank of India, my lord. Respondent number 3.
State Bank of India is present. None appeared to represent the respondent number 5. The learned register administration LOM is to serve notice upon the respondent number 5 intimating the next date of hearing and file a compliance report.
তাহলে এ তো এইটা
That
বলবে
effect.
তো
Next
এটা
date.
আপনার তো বলার কথা
Lord, I may be wrong. Possibly similar order was passed earlier. I may be wrong. So far my memory goes. After receiving the notice, the grandson of the respondent number 5 came in court and therefore applied before the legal authority, and from the legal authority, advocate was given to defend on
Next
behalf
date
of.
fixed on 23rd of September. Let us find out because these facts were not placed earlier, sir. Is it there on record?
Maybe I cannot. Record has to be
Anyway,
checked.
next.
So other than 23rd, either 22nd or 20.
24th of September.
May I be permitted to check up the or permitted to check up the deaths? Five.
Not
On
necessarily.
After quotas.
one.
Next.
For the state respondent, my lord. Last occasion, my lord, your lordship heard the matter at a length, my lord, and directed the participants to file the notes of argument, my lord. Accordingly, I am filing the notes of argument.
Last occasion, I have to file an exception against the report as filed by my Laden friend client. That is, my lord.
Exception to the report filed in the form of an affidavit.
Well, I have also served the notes of
What is
argument.
the date? That report was dated?
My lord, so far
The date of the
written
report?
notes of argument, my lord, I have to prepare because my lord, so many dates are there and so many cause of action arises by the advocates on behalf of the state. Because the 16 posts are there, only 2 posts are disputed. And there are 2 notifications in 2015 and 2016. That is most vital thing, my lord, which has already been relied in this exception. Your lordship,
Filed by the learned advocate representing the petitioner be kept on record. Written notes of argument filed by the
State
learned
respondent number
advocate.
1 to 8.
1 to 8.
And
Filed
serve the
by
copy
the
of my learned friend.
Filed by the learned advocate representing respondent number 128 be kept on record. Any hearing concluded, CAV.
Well, one thing,
The written notes of argument have not been filed by the learned advocate representing the petitioner.
Let her appear on my lord.
CAV.
CAV.
Next.
Concluded.
Because he has his own problem to prepare the notes and then file it. So he's very happy.
Very simple thing, my lord. He
I
applied
know,
for the
sir. I know
development.
how he has been made to conduct this
develop.
hearing.
Yes.
53, my lord, I am appealing for that.
Yes, madam.
My lord,
Mr. Mitra.
reply.
Where is the affidavit in reply? Affidavit in reply filed by the learned advocate representing the petitioner, serving a copy of the same upon the learned advocate representing the Respondent Union of India be kept on record. Next date be fixed on 13th of November for hearing. Next date. None appeared to represent either of the parties. Let the
I am for the petitioner, my lord.
You are for the petitioner?
I am for the petitioner.
Acha. So where is your written note? Did you file it?
My lord,
Written note?
my lord, I have to place my case on merit. Thereafter, my lord, written notes. If
But
request,
there was a direction earlier.
no, I have not yet, my lord, placed my case on merit.
Did you ever say that you will file the written notes?
No, my lord, if your lordship direct me, I shall file.
Sir,
But-
I'm asking you, did you ever did you ever say that you will be filing the written notes?
My lord, I must file a written notes. But your lordship kindly give me a chance to place my case on merit.
Did I say, sir, that I will not give you the chance? You, did you ever say so? Because there's a line in the order. He is to file written notes of arguments. So I'm asking you, did you ever, generally you say that I will file written notes.
Yes.
On that day, did you say? You might have. Now you have forgotten. Tell me, what is your case? Who is your other side? Every day a new advocate arrives. Yes, sir. What is your matter?
Kindly come to what is the charge against me? Page 30.
I think I've heard this because I have my notes here. Anyway, sir, tell me. Page 30.
Yes. Imputation of allegation. Lordship kindly see imputation of allegation. और शासन सर देश श्री आर तिवारी ASI of T. Koi Tata now at MISL Chakradharpur was performing duty as train escorting in charge duty from Tatanagar to Rourkela and back. While he was performing duty as a train escorting in charge in train number such and such, takes Rourkela to Chakradharpur with arms and ammunition on 20th-10-2030 at about 23 hours on such and such day, the theft of passenger belongings to vanity bag of a bona fide lady.
Yes, madam. Yes, sir.
Bona fide lady passenger traveling in coach number such and such took place at Rourkela station just after start of train from Rourkela station, resulting which aggrieved passenger repeatedly pulled the alarm chain of said train for lodging FIR and was demanding for recovery of stolen materials at the spot. But the escorting in charge, Sri Tiwari, neither prevented or detected the theft nor gave the FIR from on demand by aggrieved passenger, and also failed to tackle the situation properly, and due to his behavior, passenger became more aggressive and made repeated ACP, and the said suffered detention for more than 2 hours. Also, the victim passenger and the other passenger passed adverse remark against RPF. Also, he was found in intoxicated state. This is the malord allegation. Now, Lordship, kindly come to the findings of the N-Court official.
Yes, page 34, 5. You had earlier mentioned page 35, brief statement, PW1 Sri Hatin Jarif.
Yes. Now, my lord, the PW1, he is the eyewitness of the incident. He is the relative of the lady passenger. What he said, my lord. Now, my lord, before that, I am, my lord, listening before lordship, that I am not only the person who was placed for preventing and detecting theft. 13 RPF constable with 3 civil dress. I have, my lord, paragraph 4, I have stated that in my writ petition. Basically, paragraph 4, the petitioner stated that on 10th October 2013, 1 SI and 13 staff of RPSF and 5 staff of RPF of the T. Koi Tata, including 1 staff in civil dress under the command of ASI Sri R. Tiwari, petitioner of T. Tata, was detailed to escort the train. So I am not alone to escort the train. Now, my lord.
So if you don't, if you had on any circumstances failed, the others would have been responsible for that.
Everything beyond the evidence on record. Lordship, kindly come.
They must have been posted at different compartments.
My lord?
The others must have been posted at different compartments.
Yes. Entire train, my lord, was escorted. by these RPF people. Now, my lord, what happened? When the train started, a criminal, my lord, suddenly, my lord, snatched the vanity bag of the lady passenger. I was on duty in rear, my lord. Your lordship, kindly see what the PW1, he is the only, my lord, the eyewitness of the page 35. Shri Hatib Jarib deposed his statement that he was traveling by train number such and such in coach number S2 with his family and friends, ride number such and such. At about such and such, just after departure from Raurkela, one outsider criminal snatched lady's handbag, vanity bag of his wife from window side of platform
The
number.
proceedings were initiated against him.
My lord,
Proceedings were initiated against him.
only against me. No one, none. Lordship, kindly see the findings of the inquiry officer.
You had been asked to compulsorily retire.
Retire.
You received all your benefits.
No, no.
You didn't receive? Which
Now,
order?
from the
Which
evidence on
page?
record, it is on record that all the RPF people are there. They are also responsible for the same, if I was held responsible. Lordship, kindly see page 35. In reply of cross-examination of question number 4, second paragraph, a party charge, he stated that no, it is not a fact. In reply to question number 5 of party charge, he stated that the said train suffered detention due to theft took place and required assistance had been not provided in time by RPF, GRPF. Kindly mark it. By RPF, GRPF as well as on duty train guard. Now your lordship kindly come the PW4, page 36. PW4, what is said?
What did Dr. B.C. Panda?
B.C. Panda, yes. As regard to the malord, the intoxication, it is malord the alleged that I was in intoxicated mood. Lordship kindly see what is
He
B.C.
deposed
Panda?
in his statement that Sri Rajendra Tiwari, ASI RPF,
Examined by him on
was examined by him on such
regarding
and such
drunkenness.
regarding
Further deposed,
drunkenness.
the Rajendra Tiwari consumed the alcohol as clinically found, and his blood sample was also collected from the party but could not send to laboratory for chemical analysis due to unavoidable technical problem. So that was not clinically found. It cannot be the evidence. In the reply of cross-examination of question number 2, no definite percentage can be ascertained in the blood sample as same facility not available at railway hospital, Mandamunda. In reply of question number 3 of the party charge, he said that the collected blood sample should have been sent to Central Pathological Laboratory in Nagpur for analysis of the alcohol, but it could not be sent to the laboratory because of unavailable technical facilities. In answer to question number 4, he stated that the blood sample was not analyzed because of faulty technique. This is the doctor's statement. Now your lordship kindly come to PW4. He is the inspector. He made a preliminary inquiry. What is stated? Shri Sudhir Kumar, inspector, page 36, bottom. T. Koi Tata deposed in his statement that he was the inspector in charge of Andamunda. He was instructed to conduct preliminary inquiry. Neglect of duty of Art Theory. ASI T. Koi. Accordingly, he inquired and submit preliminary inquiry report dated such as such. Next paragraph, very important, 2 lines. In the cross-examination by question number such and such party charge, he replied, yes, it is fact that the bona fide passenger belonging was taken place at Raurkela platform number such and such. In question number 2, yes, it is the duty, lordship kindly mark it. It is the duty of the inspector in charge as well as GRP concerned to keep the station area free from indispensable elements, criminals. It is their duty. It is not my duty. Now your lordship kindly come to my lord PW5.
So you
also
tell me the lapses
Last,
where
my
I,
lord, the findings
because
of the-
there is hardly any scope to reappreciate the evidence.
Yes. Now logically come to the findings of the in-court officer. Logically come to page 40.
Yes.
Different statement of Sri R. Tiwari, ASI, Tokodaku. In his written defense statement, first para he requested for kind disposal, second para said not necessary. Then you logically in paragraph 4th and 5th and 6th. He also raised question on inquiry conducted by you. Further, he has also raised natural question about joint responsibility of full escort team rather than only of escort party in charge. It is my first point. Next, in para 7, he has mentioned the complainant Sri Hatim Jarif stated that no misbehave has been done by him and required assistance not provided by RPF, GRPF, and train guard. He also stated that the train suffered detention due to complainant Hatim Jarif. In para 8, he has stated that Dr. Bishi Panda examined him and took his blood sample but could not send to laboratory for chemical examination. Then you logically come to in para 9, he mentioned that PW Sudhir Kumar, Inspector RPF Bandamunda disclosed that it is duty of the inspector in charge of RPF as well as GRPF concerned to keep the station area free from criminals. Next, my lord, in para 10, he made Rajesh Mohan with an inspector. He stated that the statement of Rakesh Mohan is not only to save himself and the social side. In para 15, logically come to that he is not responsible for charge of fail to prevent and detect the passenger belonging. And because the said train was escorted himself only, further he, along with ASI G. Kotwal, tried to recover the said stolen material, but none either GRP or RPF take any efforts in this regard, although they have performed same nature of duty. In para 16, he denied the charge of intoxication on the ground as his blood sample was not sent for chemical examination and also as per statement of ASI G. Katwal. Now, my lord, I have taken all this defense point. Now, logically come the findings of the in-court officer. Fact in issue. Lordship, page 43. 7.
Yes.
Fact in issue. Whether the party charge was detailed for escorting duty at 10 number Sasan Sat, Rautpalla as party in charge on Sasan Sat. My lord? Yes. 7B, yes. Then, whether the party charge was in intoxicated state? Yes. No evidence, no discussion, nothing, only yes. Then, it is a fact that passenger became more aggressive to see the escort party in charge in intoxicated state? Yes. No evidence, nothing discussion. Whether the affair was provided by SI Tiwari station, is it behavior of party charge was wrong with complainant? So yes, yes, yes. But no evidence, no discussion of the evidence. Now, discussion on evidence and noting all PWs examined have confirmed the theft of passenger belonging to took place on Sasasa day. The said train was escorted by RPF and RPF personnel. Logically market. RPF and RPF personnel under the in charge of RTWari. Stolen passenger belonging also could not recover. As per statement of PW1, Hatim Jari requires assistance and FIR forms could not be provided by RPF and CRPF, GRPF. Not myself, no. The statement of PW1, 2, 3 have confirmed the intoxicated state of party charge. Clinical examination DMO BC Panda has also confirmed the intoxication. The said train suffered detention, the reason of detention. Now, my lord, what is the consideration of my defense point? I have taken all the defense point. He quoted the defense point, but not a discussion. So this is non-application of mine. And in this connection, my lord, I am placing the FX court judgment that being a quasi-judicial authority, you will have to discuss the statement, you will have to discuss the written defense statement, and then you will have to disclose findings. That's as to why the grounds disclosed by the delinquent employee was not considered.
And what evidence on record? Well, my lord, is on record. The statement was true. Nothing was, my lord, discussed. Only yes, yes, yes. He did not discuss even the evidence. Which evidence? And even he did not discuss any point of my written defense statement. That was, my lord, I have taken, but he did not discuss. So this is suffered from non-application of mine. On this, my lord, ground, my lord, I am placing one judgment before your lordship.
Give advocate. Well, if yes, don't know. Because possibly because he was found wrong. Possibly because he was found wrong. Possibly. But he was caught, man. No.
And if you are in dire need, then also you will not find them.
No, in most of these cases, I found
You must also face this.
yes.
Yes.
Well, RPF people I see going around only when they are trying to catch hold of ticketless passengers to get money. That is the only time they take rounds to who to catch. So they'll take money. Man.
Back to the TT informs.
And when there are too many people, they are not there.
Yes.
Reserved bogies filled with outsiders, they are not there. This is a habit. Man. That is why in these things, whenever read code gets chance to dismiss every petition. Because there are the few people who have got caught. There are others who don't even get caught. So possibly he was the person who was there present, and this his commandant or whoever the person was there must have seen that he is in a drunk state. When an incident appeared, they must have gathered together or they must have discussed with each other. So he must have smelled something, or that is why he got caught.
Yes, sir.
Now, my lord, I am
Well,
putting the judgment.
I have another matter.
Similar.
No, they were taking money.
They were taking money.
And in another matter before division bench, I have got an order based on other Supreme Court judge that discipline of the forces will be considered higher in degree. This word has been used. So they will be judged at a higher degree, other than normal civilians. So where a person can get away with minor punishment or a punishment not amounting to removing him service, in this
Here he had been compulsorily retired.
he has got his retirement benefits. There are cases where they are dismissed. I told you on the other occasion, they were beating each other up. Both of them dismissed.
Yes, sir. You are still on the facts.
Now, my lord, I am placing a judgment on the point non-application of mine. Lordship kindly see what the apex court says. Paragraph 5 and 6. In 1985 Supreme Court cases, they were on service. And they Lordship kindly go through paragraph 5 and 6.
We have extracted the charge framed against the appellant. We have also pointed out in clear terms the report of the inquiry officer. It is well settled that a disciplinary inquiry has to be a quasi-judicial inquiry held according to the principle of natural justice, and the inquiry officer has a duty to act judicially. The inquiry officer did not apply his mind to the evidence. Save setting out the names of the witnesses, he did not discuss the evidence. Well, that is my also case. He did not assign a single reason why the evidence produced by the appellant did not appeal to him or was considered not creditable. He did not permit a peep into his mind as to why the evidence produced by the management appealed to him in preference to the evidence produced by the appellant. An inquiry report is a quasi-judicial inquiry, must show the reason for the conclusion. It cannot be an ipse fixit of the inquiry officer. It has to be a speaking order in sense that the conclusion supported by reason. This is too well settled to be supported by precedent in Madhya Pradesh Industries versus Sassan. This court observed that a speaking order will at least be reasonable and it ought to be least or a plausible one. The public should not be deprived of this only safeguard. This court reiterated that satisfactory decision of a disputed claim may be reached only if it is supported by the most cogent reason that appeal to the authority. It should all the more be so where the quasi-judicial inquiry may result in deprivation of the livelihood or status to stigma to the character.
Okay, sir, we'll keep it till here today and we'll continue on the next date. Okay. Sir, I'll keep a copy of.
Well, your lordship, keep it with your lordship.
So you refer to paragraph 5 and 6.
5 and 6.
Sir, on the next date, you will finish it off? On the next date, you will conclude?
Yes, yes.
Heard the submission of learned advocate representing the petitioner, none appeared to represent the respondent railways. Next date be fixed on 19th of November for final hearing. 19th of November.
Make it September.
September, sir, you know how it is. It won't be possible in September. Next.
19th November.
On the last occasion, my lord, I submitted the core points, the basic issue of the case. Now, my lord, I will be praying my lord's leave to take your lordship to the writ petition. Kindly come to paragraph 2, my lord. That by a public advertisement published, uploaded in their website in 2009, the respondent number 1 company is Coal India Limited, invited applications from Indian nationals for recruitment of executives for CIL and subsidiary companies. To brief your lordship, Coal India is the holding company. There are 8 companies under it who are subsidiaries. Executives are recruited centrally and allocated to different subsidiaries according to need. Inter alia for 6 posts of deputy manager, public relations, and or for senior public relation officer at the pay scale of such and such. Advertisement had 2 arms. If you are qualified this much, you may be considered for deputy manager.
If you are considered this much, you will be qualified for senior manager. Advertisement minimum is annexure P1,
Yes, page 29.
page 29.
E4, E3.
The material part is E3 because we have been recruited as E3. Kindly see the last entry qualification. Postgraduate or MBA or PG diploma or graduate degree in public relations, mass communication, journalism, graphic designing, and multimedia from recognized university or institute of repute. Experience is important. Next page. Should have 4 years and 7 years post qualification experience. For E3, it was 4. For deputy manager, it was E7, 7 years. As public relation executive in large public sector undertaking, or must have served in corporate communication and public relation discipline of a large private sector, having a minimum turnover of rupees 100 crores for a period of 4 years for E3 and 7 years for E4. Or experience of working for a period of 4 years for E3 and 7 years for E4 as journalist in large newspapers, magazine, having circulation of 75,000 and above. Now the parameters are there, how the eligibility will be determined. Kindly come to paragraph 4 of the petition. That being in possession of the requisite experience, qualification, and additional qualities as stipulated in the advertisement annexure P1, the petitioners herein applied for the post advertised for and having successfully negotiated the interview were appointed as assistant manager PR in August 2010. The date is important. August 2010. Previous designation was senior manager, public relations. That nomenclature was changed. There is no dispute about that. Offer letters are at page annexure P2 and P3. Because initially there were 2 writ petitioners. The third, which your lordship leave, has joined later on. Fifth, that a compendium of rules framed by the board of directors of CIL, known as Common Coal Cadre, as amended from time to time, governs the service conditions of the executives of Coal India Limited. The petitioners crave leave of this honorable court to refer to the Common Coal Cadre as and when required during the hearing. I will be referring to it. In the meantime, there is a development. Now, Coal India has reframed their Common Coal Cadre and named it HR Manual, including the Common Coal Cadre and later amendments and everything. That in August 2010, paragraph 6. One more thing important. There are about 34 disciplines in which the executives are recruited, retained, and grown.
Sir, according to you, if my memory doesn't go wrong, you were seeking parity as that of the medical officers,
Lordship.
that they had been given certain advantage.
Lordship.
You also sought for the same.
Lordship. I am approaching this way because I am not asking from just for the heaven. What has happened, I am telling you, Lordship. Management trainees vis-a-vis us, we are recruited as E3 with post-qualification experience. Management trainees are recruited as E1, used to be recruited, now it has changed. E1, and after probation, they would be absorbed in E2. They were absolute greenhorns, fresh from college. Even campus recruitees were there. Why I said the date is important, because with me or subsequent to me, many people are recruited as management trainees in E1 grade. Some are after me, some are with me, the same time, more or less. Now in 2012, there was a development. I will come straight to that. That is more important. Before that, kindly once pause at paragraph 7. that the writ petitioners were recruited and appointed directly in E3 grade in August 2010. In the same manner as the medical officers with specialization, why I derive the parity, why I pray for the parity. In the same manner as the medical officers with specializations used to be recruited, appointed from outside, and for such appointment directly at E3 grade, the petitioner had to have, beside the professional qualification, 4 years post-qualification experience in a large public sector undertaking or private sector, having a minimum turnover of such and such. Last line, unlike the management trainees, the petitioners could not be greenhorns, fresh from an institute. That is the crux of the issue. Kindly come to paragraph 9 at page 8. That when the petitioners were working as assistant managers, PR, in E3 grade at Northern Coalfields Limited and Mohanodi Coalfields Limited during 2012, the respondent number 1 company did a major overhauling of its recruitment and absorption policy in respect of the management trainees in general across the disciplines. It also introduced similar reorientation in respect of the executives of the medical discipline. Kindly recall, my lord, medical discipline people are never recruited as management trainees. They are recruited directly as doctors in E3 grade. Similarly, with post-qualification experience, we are also recruited in E3 grade. There was a overall orchestrated arrangement in the recruitment policy. There was an equilibrium. Equilibrium not in respect of horizontal development of an executive only in his discipline. I try to impress upon your lordship that this sense of equality is also applicable horizontally, not only vertically. Not only vertically, it has to be horizontally also. I have been recruited in the company as E1. He has been recruited in E3. Somebody has been E4. This recruitment, though for different disciplines, in a company, they are in a position to address each other as sir or not, or by the first name. In a company, this parity, this similarity matters. Factually, your lordship, what happens? Executives in Coal India, in this kind of organizations, live in colonies, gated colonies. There are pockets of their quarters. I was recruited in E3. Somebody was in E1. Now suddenly, on a fine morning, you upgrade that E1 to E3. With effect from a retrospective date, from the date of his recruitment. It was a breach in the orchestra. It was a breach in the equilibrium. I am trying to impress upon your lordship that sense of equality under Article 16 is not one-dimensional. If I say somebody, you are fair complexioned, you are black complexioned, you are not equal. That is one thing. If I say your height is 5 feet plus, you are 4 feet plus, that is also equality or inequality, so to say. It is multidimensional. It cannot be a straight iron jacket thing. If it is a discipline, you have to be equated with the members of that discipline only. Not only vertically, it should be horizontal as well. I know, my lord, I have one drawback in my case. All the law has been developed in this line, that there cannot be inequality in the discipline. You can claim parity with your colleagues in that discipline only. Sitting in this jurisdiction, your lordship, I beseech your lordship to take a broader view of the matter. Not only that, narrow view. And I'm not asking for the heaven. We are only 3 people.
So they were designated as senior specialists.
Yes, doctors. Doctors are designated as such. We are public relation officer, senior manager.
Senior?
Manager, senior manager. Senior manager or senior assistant. Assistant managers, PR 3. Assistant managers, PR 3. Now I am reading out paragraph 9. That when the writ petitioners were working as assistant managers PR in E3 grade at Northern Coalfields Limited and Mahanadi Coalfields Limited during 2012, that is 2 years after their recruitment, they were entered in the company in August 2010, and this is 2012. The respondent number 1 company did a major overhauling of its recruitment and absorption policy in respect of the management trainees in general across the disciplines. And there was a disbalance created between the management trainees, the doctors, and ourselves. So long, so far, management trainees were much below us. Now, overnight, they have been upgraded. And even against that also, I have no grievance. What wrong they have done, I will show to your lordship. These changes brought about have had major consequences. The said changes adversely affected the petitioners, jeopardized their careers as executives in CIL, their relative status and position in the hierarchy of the service of CIL suffered a major setback. Now kindly come to paragraph 10. That the board of directors of CIL, they are the god in Coal India. It is a company. It is a company. So company speaks through, acts through, does anything it does through the board of directors. Board of directors of CIL in the 27th meeting held on 30th January 2012 approved the following. What are the approvals? A, small a. Recruitment of management trainee of all discipline either through open advertisement or through campus will be in E2 grade in the first year. It used to be E1. Henceforth it will be E2. And they will be placed in E3 grade after successful completion of 1 year training. B, small b, page 9. Here they did a patently wrong thing. Management trainees who are at present in E1 grade, any law, your lordship, any delegated legislation, any order, any directive by the government or organization akin to a government is prospective. Henceforth it will be done. Management trainees who are at present E1 grade or those management trainees who have been appointed on or after 1/1/2007 would be deemed to have been appointed in E2 grade. And after successful completion of the requisite training, they would be deemed to have been placed in E3 grade, and their pay would be appropriately fixed. This retrospective operation, that pinches. That is where the shoe pinches. You take up a policy, you promulgate a policy, give it operation. We are not that fool to believe that the employer doesn't have the power. Employer has a inherent authority to decide on the basis of what qualification, what experience they will be taking in people. The shoe pinches here. The people who were recruited along with me as E1 and me as E3 have been suddenly given an upliftment. It's not that, henceforth it will be so. Existing people.
So are you in the same cadre?
Pardon?
Are you in the same cadre, being the medical officers?
No. I'm not. We are different. Medical cadre is different cadre. Management training across the all discipline other than medicine. I am PR. There are about 34 disciplines. But what the question which vexes my mind, why the medical people were compensated? By a subsequent order, they were given this benefit. The benefit given to the management trainees, if prospective, I have no grievance. It is retrospective, so I am aggrieved. Naturally, just like ourselves, the medical people are also aggrieved. They were recruited as E3. Now, in their case, in the case of medical disciplines, the company provided a remedy. They gave a solace. Joel, you are E3. Today I have uplifted people from E1 to E3 directly with retrospective effect. So, you too will be uplifted, upgraded, one post above E3, that is E4, with retrospective effect. What made us difficult? They were blue-eyed boys.
Challenging this discrimination.
Patent discrimination. Patent discrimination.
Moreover, they had been fresh from the oven and you had considerable experience.
Experience.
So there, your formidability.
My status in the company hierarchy were adversely affected. Just simply imagine, your lordship.
But sir, you are not in the same cadre. Then where is the question of hierarchy?
Because
Two different streams.
Streams.
Streams are distinct.
Therefore, my lord, I'm hammering on this point. The equality cannot be taken a narrow view of. It is also horizontal. Proportionality. I was recruited E1, E3. They were E1. Doctors were E3. You maintain this proportionality. They did this in case of doctors who were left out. The reason being, Lord, I suspect.
So three of you were left out.
We were left out. And such a mighty big organization, a money-rich company like Coal India, would suffer nothing, not a pinch, if three people are given the same benefit. Let us recruit
So you had representations filed.
Lordship, a number of them.
So what was their reply?
It elicited no reply whatsoever. We tried our best not to come to court. I'll be coming to the presentation as well. Then Lordship, small c, at page 9. All those management trainees who have been placed in E2 grade on successful...
Sir, I have more or less understood your case, sir.
That is very fortunate for me.
Yes, sir, because on earlier two occasions, you also explained pretty well. So, sir, let's wind up.
I will be pressing the annexures, Lordship.
Yes, you just show me where your representations had been refused.
And your Lordship rightly pointed out, I am a different stream. Equally, doctors are in a different stream. Coal India need not have given them that benefit to them also. If the reason is the doctors are, there is a rate of attrition is very high on their part. Very often doctors leave the company.
Yes, sir, that is why I said you felt to be discriminated.
I'm discriminated. Secondly, doctors are a big company. They're a big, large number of people. In every company, there are 50, 60, 100 doctors. And throughout coal India, we are
Had been a minority.
we're a minority. It is a company law language, is a minority separation. And the representation I will showing to your lordship.
I've seen the representation, sir. I just wanted to know whether they had
Not been
replied
replied.
to your
No,
representation.
I made a categorical statement to that effect. Now, representation সম্বন্ধে কমেন্টটা করেছি যে আমি কোনো রিপ্লাই পেলাম না।
You desire fair and equal treatment.
Lordship, that's all. I don't want any areas of pay, nothing like that. Restore my status, that's all. That is the long and short of the problem.
But then your status remains the same. Only these people have.
Let me be a bit
So that is-
out of the track, beat out of the track. It is a very famous anecdote. Very famous anecdote. Your lordship knows, must be knowing the stories between Akbar and Birbal. Emperor Akbar and his courtier Birbal.
So your issue is more mental, more psychological.
Lordship, it is. It is. Psychology is a hard science now, my lord. Psychology is a hard science. Scientists are working on it, not law graduate or arts graduate like me. Scientists are working on it. This is science. This is question of motivation. This is question of respect.
So we
Otherwise, there will be no. Otherwise,
Sir,
there will be no law of defamation at all.
Yes, sir. I would have liked to listen to your experience and oratory. Sir, we have other matters also today. Because we were running late by 1.5 hours today, literally. Ashwin. You get yourself prepared. Why have you done this to them?
Yes.
If you could have given that benefit to others, recognition, they want recognition as seniors. Why did you
deny them that?
Why did you?
Their Coal India's contention is they have no cadre. Maybe, may not be.
Can it be?
We are ex-cadre people. We will continue, of course.
Can it be marked part-third?
Why?
Anytime, as per my lord.
No, I said why?
Because my lord has.
Harder than
We wish to complete this matter before my lord. If my lord gives us that opportunity.
I support my learned friend. Your lordship has already got the issue. It will be convenient for us.
Subject to my lord's.
No, earlier I used to do that, but the moment I have come on the consent of the learned, on the prayer of the learned advocate representing both the parties, let the matter be marked as part-heard.
That's Mr.
Then after vacation, prior to that, there's hardly any time. Next date is fixed on 19th of November, sir. In your
Well, we're extremely good.
Grateful, my lord.
On the 77, your lordship kindly take up tomorrow.
It's
No.
already marked in the list.
77, my lord.
Yes, 77 only has been called.
Yes, my lord. 77, your lordship kindly take it up tomorrow with 78. Same matter, my lord, same incident. RPF. My lord.
Acha.
And what the petitioner?
I am for the petition.
Same issue.
Same issue, same issue. Both were taking money, my lord.
And this is the clear case how the petitioner was the victim of the in the hand of the authority. No witness, nothing is there. Participant is given.
It was circulated. Somebody.
No witness came forward
Why
to
do
prove
you
the charge.
victimize people?
Well, I have the video. I will show it, my lord.
Yes,
A video was taken by passengers, and they circulated it on the social media.
Forward.
Which year?
Forward the matter.
2021.
Let the matter be fixed for tomorrow along with WPA 816/2020.
Tomorrow. Along with my lord the
WPA 816/2020. Next.
Thank you.
uh, 84, my lord, I appear for the petitioner, your lordship. There was a direction to file affidavit in reply. Lordship, I have prepared the affidavit in reply. It was affirmed on Friday, my lord, hence couldn't serve it upon the other.
Who are you?
I'm the petitioner, your lordship. I'm the petitioner. Dolly Sharkar, 84. Huh.
Who is this Chiranjeev Sinha?
My lord, he was the on record, and I was appearing as the counsel. My lord, then he is not nowhere to be contacted. He has given me no objection. I have filed my wakalatnama, my lord, in the department. My lord, this is my affidavit in reply. In response to the
You are the present
I'm the
advocate
present
on
on
record.
advocate on.
नामटा change कर दीजिए list.
Affidavit in reply filed by the learned advocate representing the petitioner be kept on record.
My lord, they have just served us a copy.
Right. A copy of the same has been served upon the learned advocate representing the respondent bank. What is the issue?
My lord, the issue is regarding, my lord, the disbursement of pension, my lord. The husband of the petitioner, my lord, was an employee with the State Bank of India. Now, my lord, after his demise, the writ petitioner, my lord, have claimed for disbursal of the pensionary benefit. For the first time, it has come to the knowledge of the petitioner that there was a second wife in name of whom, my lord, she was named as a nominee in respect, my lord, to the gratuity, not to the pension. My lord, thus the bank has disbursed 50% of the pension to me, and my lord, the 50% is not yet disbursed, your lordship.
And my lord, in this petition, we are supporting them. We had just intimated them that
My lord,
since bank is not the authority to decide all these issues, please get us a proper court order. And they have filed this writ petition. And in my reply also, I have said that the bank is not averse to any order passed in this writ petition. If the court directs to disburse the amount, we will do.
And my lord, the private respondents are made a party, my lord. The second wife, now, my lord, the daughter is the party. They're not contesting anymore.
They are not appearing as
They're not appearing as of now.
Who are they? Respondent number?
Respondent
5 and
number
6.
5 and 6, your lord.
None appear to represent respondent number 5 and 6. Next date be fixed on 21st of November.
Lordship.
In the meantime, you prepare a short note, maybe on maybe by the next week after 21st of November, we'll dispose it.
Lordship, I'm deeply obliged.
Next.
That as per your lordship's direction, that I following file the chart
Yes.
showing the sequential event regarding the claim of pension.
preserving my right to challenge the
3rd of
May
May
2006, the
2006, the
petitioner was
petitioner was
service
suspended.
dismissed, yes, suspended.
Was dismissed.
Then in the first round of
Sir.
disciplinary proceedings, he was dismissed
Adopted.
from 3rd of December 2007. Then normally this was challenged. Ultimately, it was set aside, 2 rounds of litigation. In the meantime, I have returned on 31st of October 2010, and I was under the previous scheme, where the pension scheme that I was entitled to get the CPF, the contribution provident fund, from my salary, which is deducted, and another part was employees' contribution. But since I was under that old scheme, thereafter bank giving a new circular giving opportunity to the employees to opt for pension, go for pension scheme, which I did not before the cut-off date of 8 November 2010, as per circular. The circular is on record also. Now, after furnishing my the option form, I requested to release the pension and other things, since in the meantime the disciplinary proceedings, the order of punishment was set aside. So in the meantime, the Honorable Justice I.P. Mukherjee, while taking up the subsequent writ petition, that is dated 25th of November 2014, Justice Mukherjee directed the bank authorities to immediately release the pension and other benefits that were admissible rule. Then after this, when this final order was passed by Justice, I'm sorry, this should be 2015, not 25. The next date, 28th August 2015, it should be. The writ petition was disposed of, in which it was recorded that in earlier writ petition, the respondent was directed to pay all consequential benefits also. Now, after the second round of litigation, when finally another fresh disciplinary proceedings initiated, I was dismissed for service with retrospective effect. I prayed for the release of the retirement benefits, since that part of the order which Danish Singh judge directed, that was not assayed, and the Supreme Court also did not say that my pension will be forfeited. Then I had to move before the controlling authority for release of the gratuity. Controlling authority, after contested hearing, allowed my prayer and directed the bank to pay the gratuity amount, which was released on.
So you are claiming.
Firstly, I am challenging
You are claiming the
pension, leave encashment, and this part only. Pension and leave encashment as per the scheme. And on affidavit, the bank says that I have not opted for. In the opposition, this is their statement, their stand.
What is the date from which you are claiming?
The pension from the date of retirement.
You said there was a subsequent delay.
Subsequent, after giving the option, when I retired, in the meantime, I gave the option in 2010. After retirement also, it's permissible. My claim is from the date of retirement, I am eligible to get the pension. Now the bank authorities relate the issue of releasing the pensions on the ground that I have not opted, which is on record is not correct. I have opted. I have prescribed I filled up the prescribed form and submitted. Bank authority received that. The bank says I've made some other representation in 2019-20. They said they will process, they will furnish to the proper authority and decide the case on merit basis. Besides my challenge to the final order of the disciplinary proceedings on merit. For the time being, this pension, since your ladyship's observed this on this pension point, I just prepared this chart.
So now you are only on the point of pension. And leave encashment.
Leave encashment, pension. This much. And I am also challenging the disciplinary or final order of the punishment on merit. But for the time being, your lordship's query was this on this. That's why
Yes, okay. And what about you had been asked to compulsorily retain?
Dismissed from service. Dismissed from service, third round of litigation. Firstly, when it was dismissed in service in 2007, it was challenged in the writ petitions.
Thereafter, you were reinstated?
No, not reinstated. It was challenged by the division bench, affirmed up to Supreme Court. Then the matter was again relegated to start de novo proceedings from the stage of furnishing the inquiry report, on the ground that the disciplinary authority, while disagreeing with some of the findings of the inquiry officer's report, did not give any reasons, did not give opportunity of hearing. So that was asserted by the bank up to Supreme Court. The Honorable Supreme Court again relegated the matter and directed the bank authority to furnish the disciplinary proceedings afresh after from the stage of inquiry report and after giving opportunity of hearing on the tentative basis. That was also passed in violation of the Supreme Court's order. So Supreme Court, the Honorable Single Bench also set aside that one. But the Honorable Single Bench, the court delegated the bank authorities to conclude the proceedings once again from that stage. So that third round of litigation, which is culminated into 2015. And thereafter in 2016, the fresh order was passed and I challenged before the appellate authority also. That was not upheld. I'm challenging that one as well as my right to get the pensions and other benefits. That's the crux of the matter.
First, let us see whatever your proceedings.
Yes, Mother. Kindly, that straightway comes to the Supreme
Lordship, in
Court's
the
order.
meantime, your Lordship, I submit before your Lordship, at first, Lordship kindly decide the read petition is maintainable or not. If the read petition is maintainable, then Lordship can heard the matter. If the read petition is not maintainable,
Why are you objecting?
Lordship, kindly come to the page number 21, prayer portion of the petition.
Point after exchange of affidavits, this point is taken.
Lordship, point of maintainability can be raised in any stage, your Lordship.
Yes, tell me, sir.
Lordship, I am submitting your Lordship, page number 21, a read in nature of mandamus directing the respondent number 7 to set aside and or to cancel and or to quash the impugned appellate order. Lordship, quashing the appellate order, setting aside the final order, it means entire disciplinary proceeding has been challenged.
Yes.
Lordship, when the disciplinary proceeding has been affirmed by the Supreme Court, your Lordship, in respect to on the basis of the inquiry and you serve the inquiry report and thereafter you pass the order as per the law, and on that view, your Lordship, the proceeding has been completed.
Where is the order of the Supreme Court?
Lordship, kindly
page number
133.
Page number, Lordship,
133.
Passed by the 133.
This impugned order is passed after the Supreme Court order. After that, single bench, division bench.
No doubt.
Thereafter, I am challenging this.
Lordship.
That the operative portion of 132. Having affirmed the findings recorded by the High Court on the issue of difference of opinion, we are of the view that the delinquent should now be afforded such an opportunity before the difference of opinion recorded by the disciplinary authority can be given effect to. Accordingly, we direct the disciplinary authority to issue a show cause notice on the difference of opinion to the respondent and take a final decision in the matter after considering the response of the respondent. The matter shall proceed further in accordance with law. Whether or not any action has been taken in furtherance of the determination rendered by the disciplinary authority will depend upon the outcome of the findings recorded by the disciplinary authority after having considered the response of the respondent. In the peculiar facts and circumstances of the case, we are constrained to observe that the disciplinary authority, which had originally recorded a finding of difference of opinion vis-a-vis the finding recorded by the inquiry officer, having made up his mind, should not be the one who should handle the proceeding hereinafter if an officer other than the punishing authority of an equivalent rank can be nominated in his place. In compliance with the prevailing rules and regulations, such authority shall be nominated to deal with the matter hereinafter. But in case it is not possible to do so, an officer superior in rank other than the erstwhile disciplinary authority shall be required to proceed with the matter in compliance with the direction issued by this court. We are informed that the respondent has since retired from the employment of the appellant, having attained the age of superannuation. In the above view of the matter, we direct the appellant to complete the entire proceedings and take a final decision in the matter within 3 months from today, failing which it shall not be open to the appellant to take any action against the respondent in furtherance of the memorandum dated 11/4/2006. We have left it open to the appellant to proceed with further in the matter from the stage indicated herein above. We are further of the view that in case the finding is recorded against the respondent and the respondent is thereafter punished, such punishment shall not entail recovery of any wages or remuneration paid to him in the meantime. After this,
Lordship, as per the direction of the Honorable Apex Court, the respondent bank proceeded the matter, but that order has been challenged by the petitioner before the coordinate bench of this Honorable Court, and only to setting aside the order of the DA and or the order of the appellate authority, Your Lordship. The Honorable coordinate bench of this Honorable High Court, Your Lordship, in page number 173, Your Lordship, passed by the Lordship Justice Arvind Banerjee, Your Lordship. In this judgment, Your Lordship, the matter has been heard in length, and thereafter, the Honorable Justice, Lordship Arvind Banerjee, Your Lordship, directed the bank, Lordship, in page number 189, Your Lordship, paragraph number 33. I am conscious of the fact that the Honorable Supreme Court, in the order dated 26th February.
my leadership kindly
Please,
read
Mr. Counsel, please.
kindly
I'm
read,
submitting before this Honorable Court.
read from
This is my-
187, everything will be clear. Page 187 onwards.
And thereafter, Your Lordship, the read petitioner
Was that disposed of within 2 months?
Lordship, thereafter, the petitioner challenged the order of the single bench before the division bench, Your Lordship. And Lordship, the division bench of this Honorable High Court affirmed the order of the single bench. Lordship, kindly come to page number 202.
That was complied with. I have
Page
challenged
number
that.
202. Page number 202.
Yes, then what happened?
Lordship, the order of
Then
the
the
single
proceed-
bench has been affirmed by the division bench.
Thereafter, what happened?
Lordship, I am submitting one by one, Your Lordship. Lordship,
Order
thereafter,
passed, I am challenging that. The order-
thereafter, Your Lordship, the department has passed the order as per the norms, as per the direction of the Honorable Court. And
That is what they have challenged in this writ petition.
Yes.
in this read petition, Your Lordship, they have challenged.
So don't waste time, right?
Lordship, then Your Lordship kindly pass a fresh order in respect to mentability, Your Lordship. My humble submission before Your Lordship.
Ashun.
How can you do that at the hearing stage?
Only by submission, I can submit.
Doesn't have right to challenge the order.
Counsel, I can submit. No, I can submit. This is my submission before this Lordship. Lordship,
Love that.
There was direction on the state respondent to file a report in the form of affidavit. But I've served my learned friend.
But I prefer my lord to file a
What
exception.
is it, sir? If you just tell me for recapitulation.
My lord, the petitioner was serving as a my lord Khatib in a mosque. Khatib is someone my lord, who professes the religious words in a mosque. But he, after his father's death, my lord, he was serving the said mosque by some local arrangements. My lord, he was not formally appointed. My lord, because his father used to serve that mosque, he had my lord, started my lord, serving the same. My lord, he had filed a writ petition on the previous occasion, praying for regularization and other benefits. This honorable coordinate bench, my lord, at page 49, my lord will find, has directed consideration of such representation, petitioner's representation, in accordance with law. Now, my
Which
lord,
page, sir?
page 49,
49.
my lord. The coordinate bench, my lord,
Within a period of 3 weeks.
my lord. Lord, it appears, my lord, this is order dated 13th June 2014. Lord, it appears that he was called for hearing, but the hearing was never concluded. Lord, under such circumstances, your lordship directed us that the hearing be concluded and a reasoned order be passed.
Yes.
Now, my lord, we have concluded the hearing. We have stated that he's entitled, he was getting 700 per month. Lord, we have said in terms of our reasoned order, which is at page 5 of this report, and will find that he is entitled to 3,000 per month in terms of certain government orders. And my lord, we have already also stated that he is entitled to certain area benefits. That is the reason order. For the regularization prayer, my lord, we have stated in our reasoned order that during hearing, my lord, he did not press the regularization part. Page 7, my lord, will kindly come to of my report.
Yes.
Dear lordship, after my lord's order, my lord, we to my lord ensure national justice, we have provided an opportunity to the petitioner to place his case. But he was present on 18 July 2025. Last line of page 7, my lord will kindly see. During hearing,
he has submitted.
Right. He's not
that
interested.
He's not interested in claiming regularization.
Right, my lord. Now, my lord, my lord will kindly turn the page, my lord, page 9. Lord, considering everything, I am of the view that the petitioner such and such is in accordance with the extent government rule shall be entitled for enhancement monthly fixed pay of 3,000 per annum with effect from 1st August 2025 until further orders, and such is also entitled to area pay scale wages in following rate. I will kindly turn the page. Page 10, my lord. Is, my lord, his fixation of his area space. So, my lord, he is getting something out of this reasoned order. Now, my lord, the reasoned order is not in challenge. My learned friend can always come with an exception, but subject to my lord's approval.
What is
my
his
lord,
prayer in the writ petition?
so he has prayed
My
for
prayer-
regularization.
Regularization is prayer. My order was there, my lord, but they have not considered it, my lord. My client, my instruction is that, my lord, they have not submitted. I am not entitled to regularization. My lord, I file an exception. My lord, 3 days time be given, my lord. Only 3 days time, my lord.
So they have falsely stated.
Yes. My kindly see the order, my lord, page 50, my lord. Specific, since the petitioner claim the petitioner are entitled to objection under the government.
File an exception.
Yes, my lord.
Allez. State manager হয়ে appear করছি না তো।
In compliance with the order dated 13th of June, no, 13th. 2nd of May, sir.
My lord, initially 2nd of May, thereafter, my lord, we
2nd
failed.
of May 2025. And 5th of August 2025, the learned advocate representing the state
State, my lord.
has filed the report in the form of an affidavit, serving a copy of the same upon the learned advocate representing the petitioner. Let the same be kept on record. The learned advocate representing the petitioner submits to file an exception to the same. Next date be fixed on 21st of November.
We are grateful, my lord.
Grateful. Acha. We,
I pay for the respondent, ma'am. My lord, I have prepared a notes of argument. In the last order, your lordship has said that if the parties desires, my lord, they can file a notes of argument. This is.
Lord, I have not got, because Lord, on previous occasion, I argued some part, Lord, and Lord, I want to, Lord, make my oral argument first, then Lord, I shall.
You did not?
I will. I shall. আমাকে একটা copy দিন তাহলে।
আপনি শেষ করে নিন, আমি দিয়ে দিচ্ছি।
I think I have heard you, sir, on earlier occasion.
No,
Yes, my lord, he has started. My lord, he did not conclude. Your lordship says that they
Yes,
we
what is it? Just tell me for the purpose of recapitulation.
The petitioner was a branch manager of a Blood respondent bank, and Blood just prior to fortnight prior to his superannuation, Blood the present departmental proceeding was initiated. Blood he was given the major punishment by the disciplinary authority, that was Blood increment of reducing the increment. That order was challenged up to the Blood review authority. I lost in the appellate authority. I also lost the review authority. Now, Lord, before your lordship, Lord, the three orders are challenged. Lord, the basic challenge is that, Lord, the kindly come to Lord the chart sheet page 60 to 64. This is Lord,
64.
60 from 60 it starts up to 64.
Yes.
This chart sheet was issued, Lord, just 11 days prior to my superannuation. I was superannuated from the service on November 30, 2019. Lord, the charge was that, Lord, kindly skip over the next page, Lord, the page 61, article 1. He was deputed to visit the branch office, Joynagar, Mojillapur, Kolkata, to find out the lapse irregularities alleged to be committed by the branch head while sanctioning the various loan at the branch. Sri Ghosh did not, that is the petitioner before your lordship, did not do justice to it by concealing the lapse irregularities and not reporting to circle office properly. Next, Lord, the article of the charge 1, page 62. That is very much important. Lord, I am reading the page 62.
What does it mean? He focused on completions of the documents.
If I may indicate,
formally
your
without
lordship.
knowing the actual purpose of lending.
My lord, may I indicate?
Vague charge, Lord, on the basis of the vague charge, Lord, the two persons were deputed, myself and another employee. Lord, for him, Lord, the minor punishment was given. For me, the major punishment was given. By the two different, Lord, the disciplinary authority was started. Disciplinary proceeding was started. Lord,
So this is a different branch.
No, same branch.
My lord, may I
Same
indicate
disciplinary
what has
authority.
happened? Your lordship.
Same branch, same disciplinary authority, same appellate authority, same review authority. Two persons were deputed.
You come to page 61.
My lord.
It says he was deputed to visit
Mojillapur.
Joynagar, Majilpur.
Joynagar, Majilpur.
Majilpur.
So where? So if he was deputed to visit that particular branch, so he belonged to another branch.
Unless he was working at Salt Lake. He was working at Salt Lake Sector 3. During the last 3 years, my lord, he was the in charge of the inspection and audit department. Hence, my lord, our work was assigned to him to visit the Joynagar Mojilpur branch and have the audit.
It's a fag end of his career.
No. My lord, that has happened in the year of 2017. The lapses were found, my lord, later on. That is why disciplinary proceedings was initiated against him. My lord, my lord,
So was
during
he instrumental
no, your
in
lordship.
disbursing the loan?
He was not instrumental in disbursing the loan. Charges were against him because, as I am indicating, your lordship, he went to the branch. He has conducted his investigation along with one Sri Partharoy.
Mean to say he detected those lapses but did not inform?
Yes, your lordship did not inform, and rather, my lord, he has tried to correct those lapses without any approval from the higher authority. That is why, my lord, he was charged.
But what he
What were the lapses?
My lord, he has indicated in his report only, your lordship. I'm just showing. My lord, the loan documents were blank.
Whether he had the wherewithal to kind of rectify those
No, your
lapses?
lordship, this was something which he has done beyond his jurisdiction.
But that is something is beyond the record. What my learned friend is.
My lord, I'll show, my lord. My lord,
But
thereafter.
kindly see the charge sheet and what he is submitting. Kindly see.
Yes, then instead of reporting the lapses, such and such, he focused on completion of documents.
Yes.
Formally without knowing the actual purpose of lending and did not highlight the specific lapses at the branch in sanctioning and disbursing various GCC loans, resulting in quick mortality and putting bank asset of approximately 900 lakhs at risk.
Lord, I will show from the record. Lord, bank did not suffer a single paisa on account of the mortality loss from their own record, and those documents
So
were
these
marked
are
as
the two charges.
my lord, yes. And Lord, those documents were marked as exhibit before the inquiry officers. I will show those documents before your lord.
Anyway, what is your grievance?
Lord, grievance is that against the impugned judgment, that is the reducing my increment.
You have to find out, you have to point out the lapses on the part
I
of
did
the,
everything, Lord. I did everything.
Wherever you have done, you just submit before this court.
Lord, I did everything. I submitted to my authority. Authority was.
I'm not on that, sir. Disciplinary proceedings was instituted against you. You are challenging that proceedings, or what are the grounds?
Lord, that is the one of the grounds. Yes, that is I am submitting. Lord, the one of the grounds, Lord, the entire punishment was based on management exhibit 2. What is that? That is why, Lord, I am submitting the background. Lord, I was deputed. I prepared the report. 2 persons prepared the report. Report was submitted before the authority. Authority concerned was satisfied with my report. After few days, one Deepak something is there, Lord, his surname, I just forget, Lord, his name. He, Deepak Kumar. Deepak Kumar was appointed by the bank to look into the other aspect of the Mojillapur branch. Then, Lord, a report was prepared against my client and another person, Mr. Partho Ghosh. And Lord, when disciplinary proceeding was initiated, that report was banked on, depended relied upon by the inquiry officers. The difficulty is that report was relied upon, report was given the evidential value, but the scribe of the report was not examined. Lord, my lord knows, the unless until the contents of the report is proved, Lord, the mere exhibit, it does not give the any evidential value. That is one of the crux of the my challenge before your lordships. And second is that, Lord, according to them, the moral, Lord, the financial loss of the bank, Lord, I will show from the own record, their own record, all these documents are marked as exhibit. Lord, the bank did not suffer a single paisa on the ground of on the head of the mortality loss. And despite that, Lord, the inquiry officer overlooked all these things and proved the charges. Blood referred the matter before the disciplinary authority. Disciplinary authority just after 14 days initiated the proceeding. The punishment was given, reducing my increment. Blood, the second thing,
participate in the proceedings?
Yes, I did. And third thing is that, Blood, when the same report was prepared by the 2 persons, myself
and the another employee. Lord, the disciplinary proceeding was segregated into two parts. For him, Lord, the minor punishment. For me, Lord, the major punishment.
Are you the senior one out of the two?
Yes.
Yes.
Yes, yes, Your Lordship.
Senior.
Senior officer.
These are the, Lord, the subject matter of challenge before your lordships.
Can you finish it off tomorrow?
Lordship, I can. Lordship, most of the things I have highlighted in my written notes, my lord, I'll be just coming back with 2-3 judgments, Your Lordship, on that issue that the writ petitioner is inviting Your Lordship, my lord, to reappreciate the evidence, my lord, and has not suffered, my lord, any kind of violation of principle of natural justice, or, my lord, that there were any lapses on the part of the disciplinary authority while conducting the inquiry. My lord, these are the 2 points, my lord, that I'll be highlighting in regard to the law and factual matrix, my lord. Any day if Your Lordship can keep, my lord, I'll come back.
Lord, instead of tomorrow, any day after this week, Lord. And Lord, I shall also submit my written notes about it.
Then you take some time at least for the submission of learned advocates representing both the parties.
আপনি কি আমাকে একটা কপি দেবেন? আমি না দিলে দেবেন না?
Next date, 17th of November, filing written notes. Right?
My lord is keeping this matter on
17th of November.
Great.
Great.
Recordta?
For the petitioner led by Mr. Shubhoshaji Banerjee, my lord. Your lordship had heard this matter, my lord. This was that corporation matter we had come up for quashing, challenging the entire proceedings on the grounds that the charge sheet disclosed only vicarious liability and nothing else. In the meantime, my lord.
Who is appearing for the state?
State, my lord, this was, I think KMC was appearing.
Mr. Imran Ali.
Well, this is the affidavit of service of the new CRAN that we had filed because, my lord, the learned judge is enforcing us to bring an order from the court of stay because there was an interim order. We had filed a CRAN application before expiry of that, but since the matter was being heard, it was only extended time to time. Last, the matter was heard, I think, on 5th of July 2023, my lord. Mr. Imran Ali had appeared for the state and...
So, he's there in the panel?
Yes, he's there in the panel.
You ask him to come tomorrow.
My lord,
Asha.
I'll ask him.
As well as this, he also Sendam appears.
Yes, Mr. Dinda and Onindo Sundar, my lord. So, my lord, I'll inform them personally and ask them to come tomorrow.
The learned advocate representing the petitioner is present. None appear to represent the KMC as well as the state. Let the matter be adjourned for the day. Tomorrow you ask them to be present.
My lord, can I pay for 2 p.m., my lord? Can it be?
It's your parted matter. It will be there. It will be fixed at 2 p.m. only. But you ensure their presence tomorrow.
My lord, I'll try my best. Affidavit of service টা তাহলে রেখে দিবেন নাকি নিয়ে নেব? রেকর্ড হলো না তো affidavit of service.
আচ্ছা অ্যাসাইন্ড একটা আছে
ওই ওখানে আছে উপরে হাতে ওনার হাতে হ্যাঁ ওই, দুজনকে পার্সোনালি সার্ভিস করতে বলবো।
Yes,
সার্ভিস
but this is my application. As my lord last day submission, nothing has been done.
Oh, yes, come.
I have a photograph sent by my client just now. Nothing has been done.
But you have not done anything.
I've done everything. My lord may appoint a special officer. They are
Yes.
telling a lie here.
Lie?
I have got my affidavit also. Affidavit has been given by my officer.
My lord, this is the photograph.
Let
5
them show
pages-
photograph.
5
My lord may
pages
send a
before,
special
this
officer.
is the situation.
Okay, who can?
70, they have, once they have said 75% done. Now they said they've done
Yes,
nothing.
thereafter they have done nothing. They took time that they have to clear
Let
the
them say
debris.
whatever, my lord may
They have to clear
special
the
officer.
debris and then. Yes.
My affidavit is there. I have also claimed 2,20,000 also from the person who is the defaulter because we have done the demolition.
Yes, sir.
That
The
notice is also there.
advocate representing the respondent, Howrah Municipal Corporation, has filed the report in the form of an affidavit in compliance with the order dated 8/8/2025 passed by this court, stating that the demolition of the unauthorized construction at premises number 11/2.
Well, Baje Shivpur.
11/1. Here is mentioned 11/1.
31
Photograph.
Howrah.
Well, it is
In
Baje.
photograph 11/1. Baje
11 by Baje Shivpur.
In photograph it is mentioned 11/1.
Okay.
In their affidavit.
What is the actual address?
11/1 Baje Shivpur.
11/1.
Baje Shivpur.
No.
But you have written 11/2.
11/2. Maybe
11/2, but it's mentioned it 11/1.
Wrongly mentioned.
Ward number 31, Howrah. Had been completed.
My lord,
It has been completed.
completed and already we have demanded a sum of rupees 2,20,000 as regards demolition costs.
I am disputing. Not completed.
I am not
cost of
asked them to give that money. I have asked the defaulter to give that money.
No.
Let them dispute whatever they do.
Demolition work has not been completed.
Yeah.
It was further submitted that the demolition of the building had been conducted on 22 dates.
22 days.
And finally, a demand notice dated 3/7/2025 was served upon the defaulter, claiming a cost to the tune of rupee cost to the tune of rupees 2,20,000.
2,20,000. At the rate of rupees 10,000 per day.
Let the said report be kept on record. The learned advocate Sir, in paragraph 12, you come to paragraph 12. That pursuant to the demolition so conducted in the said premises in question, the demolition of the entire third floor has been concluded.
And there is no
And
further demolition.
practically, there is no further demolition is required to be done, as any further demolition would cause serious damage to the foundation of the
structural stability.
portions of the premises itself. So the sanction was granted to which floor?
G plus 2.
G plus 2. ঠিক আছে বলো তুমি।
G plus 2. Actually, G plus 1. This is the
plus
third floor.
1.
That is the third floor.
There are 2 floors that are illegally unauthorized
No,
construction.
1 floor. Third floor.
Was further sub.
Yeah, let them say whatever they like. They will do the demolition.
Order, I am speaking from your order.
Howrah Municipal Corporation submitted that sanction was accorded for construction of the building at the above, at the aforesaid premises to the extent of G plus 1.
G plus 1. G plus 2.
No, madam.
Plus 2.
This is the order passed by the page 89 of my petition. G plus 1 was the sanction. They have done G plus 3. So 2 floors are.
My lord, latest special officer goes there and will finally come here with a report.
This is the one of
They are saying a lie here.
Their resolution.
And the
There is a Chile quota there in the above that we have done the demolition.
Not Chile quota.
unauthorized construction beyond the sanction
And
plan
their
to
report
have
is
been
also there.
accorded,
Let a special officer
Plus
go
one.
and they will come.
demolished.
যেই বলে দিচ্ছ তুমি করো নি।
First of the learned advocate representing the petitioner refuted the contentions of the learned advocate representing the
My lord, kindly have a look at this document.
Howrah Municipal Corporation.
This is their document. They have supplied to me.
First of, in view of the disputations between both the parties to assess the correct status of the demolition of the unauthorized construction at the aforesaid premises, let Mr. নামটা দিয়ে be appointed as a special officer to visit the aforesaid premises and file a report with regard to the sanctioned plan to have been allotted in favor of the
Promoter at the private respondent.
private respondent and the extent of unauthorized construction and the demolition of the same.
My lord, may I bring
Only
one?
one
Copy
thing.
of this order be communicated to the special officer
And we can contact with the special officer because our engineer will.
Sir, wait. Through the High Court Legal Services Committee. He is to seek assistance from the appropriate authorities
Right.
through the learned advocate representing the respondent, Howrah Municipal
Right. Grateful. My lord,
Corporation. The learned advocate representing the petitioner can be present along with the special officer so appointed by the court, as well as any representative from the respondent corporation
Right.
on the date and time of the visit of the special officer at the premises.
Right.
Next date be fixed on 21st of November
right.
for
21st
report
November
to be submitted
by the special officer.
by the special officer.
My lord, may I bring only one indulgence, my lord. During hearing, my lord, this report has been placed by my learned friend through his engineer. My lord, kindly have a look of this report.
Let the special
he has-
officer goes.
Yes,
Special officer
kindly
will see
see.
the plan.
What extent of affidavit he has been submitted. My lord, kindly see. In the bottom, my lord, the extent of my lord, the unauthorized portion is mentioned.
Anyway, sir, now you had asked,
Come on.
you will get the true picture.
Yes.
Let them come.
Who are you?
Actually, there was a talk between this client and the
No.
defaulter.
No.
When they have denied the money, and then they come again.
Okay, sir,
Or
next.
make it by affidavit. May I get back my document?
That I know everything.
Make it by affidavit.
That is happening. Between the clients.
সাইড তো কেন করছেন দাদা? বয়স হয়েছে তো।
Yes, now you have other.
The case under section 163. That is a death claim. My claim case was dismissed on the ground that the claimant have not proved the offence. This is the case. Here, the accident, your lordship kindly turn to my paper. Your lordship kindly turn to here the two the oral witnesses. One is claimant Asha Das. Asha Das and his son compensation for the death of one Nimaida. In the FIR was lodged just after 1 hours from the date of the accident. When the mother she was bicycle under the office begin oil tanker, that's the mother just come out from the mother the FIR, charges, everything has been covered, gender marked with documents and proof. And also the postmortem report, which was saved by in the left-hand side, unknown person, but subsequently the superintendent of that the hospital, Balunga Hospital, says that Imaidas is the person whose dead body was made postmortem. In spite of that, tribunal disbelieved the case that Nimaidas did not die in the accident. Now, your lordship kindly turn to page 47 to 49 of my paper. My lord, page 48, the postmortem report. My lord is an unknown male, approximate 50 years of age. Now, my lord, in the conclusion,
Where is the inquest report is on record?
Yes, your lordship kindly turn to page 47. In reference.
This is the inquest report.
No, it is a affidavit.
I asked you where is the inquest report?
Inquest report is, my lord, inquest report has not been exhibited, but the charge sheet and the FIR, your lordship kindly turn to the first information report, the written complaint.
34.
That was, my lord, done by page 34.
Now, what did the tribunal say?
Tribunal says your lordship kindly turn to tribunal finding is that after tribunal's finding is my lord page 23, 24. Page 23. May I permitted to read? On careful perusal of record, I find carbon copy on application of Asha Das dated so and so address to IC Balughat PS has been registered as GG entry number so and so on 23rd.
That
What?
you were saying you are having problem.
Yes, sorry. My lord, I will say. My lord, on careful perusal of record, I find that carbon copy of an application of Asha Das dated 23/1/2010. That was, my lord, on 22nd January 2010 at 6:30 hours at the morning.
এটা TCR আছে?
হ্যাঁ আছে। Address to IC, GDNT was made on the next date. On 23rd at which has been marked as Exhibit 6, Objective 2. Inquiry report, your lordship can find.
Exhibited ভলিউমটা নিয়ে এসো। এক্সিবিটের ভলিউমটা চাই।
Exhibit 2. Page 37, your lordship kindly see the copy of the charge sheet.
Now, what is the issue with the name?
Name is Nimai Das. Here the charge sheet witnesses is claimant Asha Das and Gaur Nitai Haldar, who also deposed before the tribunal. He was examined under section 161. And Sudhanshu Shekhar Ghosh, page 40, who is the FIR maker, also examined. And page 41, the tribunal came to conclusion that one oil tanker, he visited the place of occurrence, prepared rough sketch map.
41 তো চার্জশিটের
না বাইরে যাবি না In the postmortem on the top, unique case reference is there. Page 48. On the on 22nd January 2010. That is the date of accident. PLG PSUD case number 29/10 dated 22nd/1/2010. In the postmortem report, it appears on the top. And my lord, if your lordship kindly see the death certificate, page 54. Page 54 is a death certificate on the 22nd January 2010. My lord, West Bengal Motor Vehicles Rule C39 says, in a case, my lord, under section 140, there are 4 documents are required. Postmortem report or the death certificate, FIR copy or Panchanama. The registration certificate of the my lord vehicle. And there is no witness from the insurance company to rebut and contradict. My lord, while dictating the judgment by the tribunal, learned tribunal says that GD entry should be proof, like a criminal trial.
Yes, madam, what do you have to say? My lord, I have to find lots of, there are several discrepancies, my lord, in their chief and cross. But my lord, may I ask for, my lord, I am suffering from huge cold, my lord, today. May I submit any on any subsequent date, my lord? There are several discrepancies. Show me. My lord,
Page 9.
page 9, the chief of Asha Das, the claimant. Clause 6, that the local
Okay, you
people.
need not.
Yes. My lord, here she was saying that she was getting information of accident from the local people. Clause 6, 7, and 8, and 11, my lord. Kindly see the clause 11, my lord. When was the claim application filed?
My lord, claim application was filed on, it was a case of 2010.
Which date?
My lord, that reflected in the order sheet. Kindly see. My lord, from the TCR, the first order that was filed. It was made on affidavit.
My lord, there is no name in FIR, charge sheet,
Postmortem report, nowhere, my lord. Nowhere. Maybe Nimai Das was died. One accident was happened, but there is no nexus with the Nimai Das and with this accident.
Yes, Chanchan.
Chief of the Gaur Nitai Haldat, PW2, clause 5, para 5. Hello, kindly see. Yes, ma'am.
What? You did not say anything. I only found out everything. As always.
My lord, I am always begging, my lord, from you. I am learned many
Next.
things.
Read by Mr. Patrogos, my lord. It is online, my lord.
In that, this application could not be taken up today. Application. So I can leave.
May I just refresh your lordship's memory?
একটা কথা বলছি তোমরা তখন চার
Lordship is working overtime.
No,
Don't
you
have.
just listen to what I say.
May I just indicate what was the matter about?
No, there's not much time.
That it will be easier for your lordship to discuss.
You need not.
Dictate.
You need not.
Because as contemplated yesterday, if your lordship sends back, it will not be served.
Will you please listen to what I say? Where is your senior?
She informed me that he is on online, my lord.
Where is that report? Acha.
Last report is dated 1st April 2025, filing.
Yes.
Affirmed on
First April.
1st April.
First
itself.
April 2025.
That report will be in white page.
I've seen. It's there.
White হবে, white কোনো?
White হবে। পাঁচ থেকে নিয়ে। Impugn was 307.
There is a copy of the order.
Hello?
Copy of the order.
Which order?
Order.
There was one order by which it was remanded. Thereafter, again, they passed this order. We came and challenged. The other order,
No, it has to be completed. I mean, report had to be filed. That one. Yes, I've got it.
In February, month.
that is your lordship's order.
19 February.
No, no.
Justice Shambhudra, Honorable Justice Shambhudra Chakraborty, yes. That is 11th June 2018 order. It was found that order, Malam. 11th June. হ্যাঁ সেটা তো না সেটা তো এটা তো রিট পিটিশনে লাগানো আছে এটা এটা আগে এই এই কাজ আছে first part, not this petition, the previous petition. The fact is that he's having so many patents in his name. He has invented a particular machine by which, by taking the breath test, it may be detected as to whether a person is suffering from ulcer. There is no need for doing the gastroenterology. They come later. Yes. Not that, but they will lose. They will lose. If this machine comes in, they will lose. And I am having a patent for that. Facts of this writ petition starts from paragraph 7, page 13.
My lord. My lord. My lord.
307 is the impugned order here in this writ petition. Yes, by which they had contemplated to deny the opportunity of cross-examination, which is contrary to the first round of order.
11.4 is there, affidavit is also there.
My humble submission was that it would have been done by order of the court here itself by the report, saying that it cannot be done because if say
that it has been signed. And it is correct that it
shall, yes.
And their incident, I mean, it has surpassed any.
Well, yes, yes.
My lord, my humble submission would be if your lordship gives this pending, if they come and say that they will continue, the reason order may be supplied, and on the basis of that reason order, it may be dispatched. And he keeps it up after 2 months, let them come with the reason order and keeps it pending. Otherwise, I will not be able to agitate the issue. Then again, new set of petitions I have to file. Yes. Yes. Now, say for instance, they pass an order, whatever is the reason, legal, illegal, whatever, saying that we will proceed with the inquiry. In that case, I'll be getting an opportunity to assail my previous points which have been taken. Kindly keeps it pending only for filing of the report, so that the points are open.
Yes, yes. We will, my lord, finally, my lord, ask the, my lord, complainant whether she will be agreed or not. If he do not turn up, we will close the inquiry, my lord. We have already, my lord. Yes, yes, certainly, my lord. We have also, that's why, my lord, in affidavit, we also said, my lord. Yes, yes, we will, my lord. We already, I have advised, my lord. That's why this kind of affidavit has come, my lord. It will be closed, my lord. I can say before lordship, it will be closed. Because the complaint will not come, and in absence of her, my lord.
Close the
Yes. 11.4. And your lordship already observed, in light of this observation, we have to consider, my lord. We cannot go beyond that observation.
The last words that your lordship, that has fallen from your lordships are that reasoned order to be passed in the light of the observations made by your lordships. They have to consider.
Yes, yes, so that is already indicated. So we cannot go.
Section 11 has been.
Yes, yes.
Then shall. Thereafter, the report that you have filed.
Right.
That considered in.
My lord. Yes, yes. Only, my lord, one. 8 years.
8 years.
8 years. My lord. Nothing, my lord. Only, my lord, one thing, my lord, can record that the reason order be communicated to him, my lord, so that I can also pursue them to communicate him. It will be closed. Yes, my lord. Yes, my lord, I was. Well, I was not in this matter, my lord, initially. I subsequently, my lord, entered in this matter.
That has influenced your lordship also.
No.
My lord, I understand today your lordship would not be continuing any further. My lord, I was only inquiring if my lord, my lord, your lordship tomorrow would be taking up for orders of the claim case. My lord. Normal, যেমন